Should be good to go, Senator.
Hey, good afternoon and welcome everyone. I am Senator Sharon Carson and I represent Senate District 14. Today we'll be holding a meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting that we are holding is in compliance with the right to know law. As chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selective legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch and/or listen to the meeting on Zoom or YouTube, and via phone by following the directions and links provided on the General Court website. Number 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. Number 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. Number 4, in the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. Number 6, let's start the meeting by taking a roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during the meeting, which is required under the right to know law. I will call the roll. Senator Whitley.
Senator Whitley here in my home in Hopkinton. I'm alone in the room, but my family is in the house.
Senator Gannon.
Senator Gannon on Phillips Pond in Sandown. My 2 kids are home Zooming, so they might come through my home office.
Thank you. Senator Khan.
At home in Keene. My wife is elsewhere in the house, but I should be alone in the room.
And Senator French.
Harold French, Senator District 7, broadcasting live from my home in Canterbury, New Hampshire.
Are you alone?
Oh, I am alone in the room.
All
There's
right.
other people in the house. The doors are not locked today, so.
Watch
I don't know,
out.
Senator, if you want that broadcast. Anyway, I'm Senator Carson. I'm at my home in Londonderry. I am currently alone, but I expect my husband to come through at any time. So let's go ahead and let's begin and let's get started. We're going to open the public hearing on Senate Bill 141 FN and recognize the prime sponsor, Senator Gaida.
Thank you, Madam Chair, members of the committee. For the record, Bob Gaida, Senator from District 2. Senate Bill 141 is a result of a large public outcry concerning our Second Amendment, which, as you know, is very, very, very treasured and precious in our state. The bill is brought because the gun line is an intermediary for the FBI background check system. Anyone that purchases a handgun has to go through the state police gun line. It also deals with the return of firearms in court proceedings. Rifles and shotguns go directly through the FBI system. For the past several years, the gun line has been horribly ineffective, inefficient, and frankly is unnecessary. It was established when the Brady bill was passed and the FBI NICS system wasn't yet in place. The intention was to have the gun line go away when NICS came online. That had not happened. The gun line is responsible today for delaying the transfer of firearms to law-abiding citizens, to denying people the right to receive their firearms property back at the end of court proceedings, denying the right to appeal and basic due process, and is also, interestingly enough, the cause of people who are prohibited persons actually being able to obtain firearms. It's created a system where a law-abiding citizen has waited, in many cases, from 6 to 10 months to be cleared to buy a handgun that he or she has the constitutional right to own. The FBI is paid through our tax dollars to run firearms-related background checks with our federal tax dollars. Those checks are carried out pursuant to federal law, but not to state law. The question arises, why are we using state funds to add an extra layer of government bureaucracy to the very efficient and effective system run by the FBI? The FBI is, if you will, the parent of all gun checks. And if the FBI is, I should say differently, regardless of what avenue you use, ultimately all gun checks wind up through the auspices of the FBI. We can't choose a state system over the FBI system. That's not an option under federal law. I brought the author of the bill with me today to explain to you more in detail how our bill fixes the constitutional infringements caused by the state police gun line. Sean List is a trial attorney. He is with the firm of Lehman Major List in Concord, a partner, and he represents New Hampshire gun dealers and individuals in firearms issues, federally and statewide. He teaches continuing legal education courses to other attorneys. He teaches firearm law seminars to the public. He's an NRA certified rifle and pistol instructor. And interestingly enough, from the point of view of thoroughness of perspective on this, he also volunteers with the Domestic Violence Emergency Project, and he represents victims of domestic violence at restraining order hearings. He does so pro bono. He has a very thorough and comprehensive view of the entire system and the people that it affects. We owe it to our citizens to protect their Second Amendment rights and still conduct background checks that work for buyers, dealers, and the victims of crime without the problems that have been created and continue with the state police gun line. Thank you, Madam President. I'm sorry, Madam Chairman.
Oh, thank you. Thank you very much for your testimony. Are there any questions from the committee? Senator, I want to make sure that I heard you correctly, that you said that we had instituted the New Hampshire gun line because the NICS system hadn't come online yet. So are you telling us that we no longer need the gun line because the NICS system is up and running?
That is true. That's my assertion, and that's the premise of this bill. And I think the people that will testify behind me will much more be able to explain the intricacies and the nuances of the system, how it works and how it doesn't work, and why we really don't need a state system.
Okay, thank you.
Thank you,
Senator Gaida, Senator Khan has a question.
Thank you, Senator, for taking the question. Some of our licensure procedures in the state don't require FBI criminal background checks. They just run through the state police. Is there any impact of taking the state police out of this chain? And maybe the Department of Safety is going to address that.
I think that the department will address that better than I am able.
Thank you.
Okay. Are there any further questions? Okay. Seeing none. Thank you very much, Senator, for your testimony this afternoon.
Thank you, Madam Chair, members of the committee.
The chair is going to call Sarah Freeman.
Good afternoon. Can everyone hear me?
Yes.
My name is Sarah Freeman. I'm the Domestic Violence Program Manager for the New Hampshire Judicial Branch. The courts are not taking position on this bill. However, I am available to answer any questions that you have now or later. In my role, I am responsible for the following tasks that are directly related to this bill. 1, I supervise a group of court staff who enter, modify, and remove orders of protection from the New Hampshire State Police online telecommunications system, which in turn transmits those orders of protection into either the state database or into the NCIC protection order file. We do not enter orders directly into NICS. Instead, NICS pulls from NCIC. Currently, we enter orders of protection issued pursuant to RSAs 173B and 633-3A, as well as pursuant to RSA 169C and 597. Those orders are not mentioned in this bill, and it's unclear what effect it would have on our ability to process those orders. 2, NICS can only determine if an order of protection with a firearms prohibitor is issued against someone if the order includes both that person's name and their date of birth. On any given day, there are between 50 and 70 active New Hampshire orders of protection with firearms prohibitors that do not have a date of birth. Currently, I'm responsible for the daily transmittal of this encrypted list to the gun line unit, who uses it to ensure that a prohibited person is not able to purchase a handgun. NICS cannot access these records and possibly other records during an automatic search. 3, I provide technical assistance to court staff with respect to the processing of motions for firearm returns pursuant to RSAs 173B and 633-3A, specifically addressing the COVID-19 related backlog of gun line search requests. Finally, pursuant to RSA 173B5-9A, I am responsible for immediately notifying a person protected by an active domestic violence order of protection of any attempt by a defendant to purchase a handgun. This notification enables a victim of domestic violence to engage in additional safety planning as needed. With the abolishment of the gun line unit, this protection would effectively be nullified. Thank you, and I'm available for questions.
Okay, thank you very much for your testimony. Are there any questions from the committee? Senator Khan?
I'm sorry, that was going pretty quick, Ms. Freeman, and if you'll take this question, I'd appreciate it. If it back to the NICS, what is it the NICS can't access?
So we have a list of 40 to 70 orders of protection every day that do not have a date of birth associated with them. These are typically temporary orders of protection where the plaintiff doesn't know the defendant's date of birth. Some of those we will get later after the police serve that order of protection, but some of these we will never have a date of birth. The way NICS works is that name and date of birth is run through a search. For these particular orders, since there's no date of birth, there's no way to automatically pull that information. So right now, the gun line manually checks this list of 50 to 70 names to make sure that a name isn't on the list, even though we don't have their date of birth.
And may I follow?
Yes, Senator.
I want to understand the list. It must be a cumulative list, yes, that some names stay on there for 2 weeks, some might be on there for the duration of a protection order, yes?
Correct.
Okay. Are there any further questions?
I guess last one.
Yes, Senator Khan.
So the list of protective orders, this is maintained at any kind of central level?
So the list of the 50 to 70 orders without dates of birth are maintained here in Concord at the Trial Court Center.
And those are collected through the county circuit courts?
Through the states, yes. So each circuit court submits those every day to the protection order registry.
Thank you.
Are there any further questions? I have a question, Ms. Freeman, and I'm looking at the section, and unfortunately, I don't have a numbered line copy of the bill. It's section 3 on, I have page 3, new paragraph, protections of persons from domestic violence. And if you go into section 4, line on the second line, it says within 24 hours of issuance, be submitted by the court into the NICS system directly, or alternatively transmitted to the New Hampshire Department of Safety to be added to the next system within 24 hours of receipt. Does that, in your opinion, satisfy the concern that you had about the transmittal of information?
So just to be precise, we transmit orders of protection into the state database, which is for orders that do not qualify for NCIC, and then into NCIC's protection order file. NICS pulls information from lots of different systems, including NCIC and others. So we don't transmit anything directly to NICS. We transmit things directly to NCIC or the state database. And this bill addresses both 173B orders and 633A stocking orders, but doesn't address 169C orders or 597 orders.
Okay. Okay, thank you. Because again, the legislation here would say be submitted by the court into the NICS system. And so the way it sounds, they don't do that now. The information goes into the database. So, okay, I just wanted to make sure that I was clear on that process. Are there any further questions? Seeing none, thank you very much, Ms. Freeman. Margaret, is there someone from the Department of Safety in the waiting room? At the list of people that I have signed up, there's a Michael McQuaid from the Division of State Police, but he has signed up not to testify. Do you know offhand if there's someone in the waiting room from the state police who would want to testify?
Yes, they just raised their hand, so it looks like it.
Okay, why don't we recognize them, because no one from the department has signed up to actually testify.
Okay.
So. Good afternoon, Lieutenant McQuaid.
Hi. Good afternoon, committee. Initially, the Department of Safety wasn't going to testify, but I'm available to answer any questions that you may have.
Okay, can you walk us through the procedures concerning the gun line?
From start to finish on the gun line for all commercial sales of handguns or other components, they go through an FFL, which is a federal firearms licensee. The FFL submits the request for a criminal background check. That criminal background check is done by utilizing the 3 federal databases and a direct state query with the state of New Hampshire. We then respond back with either an approval, delay, or a denial. The problem is, that's the easy part. The problem is that the gun line actually has to, if you have a simple assault case, the simple assault case has to be, we have to research it with either the court or the PD of record for the arrest to determine whether or not the victim in that assault case meets the federal definition of domestic violence. And that federal definition of domestic violence would then make them disqualified under 922G.
Okay. Are there any questions from the committee as to how this process works? Okay, seeing none. Oh, Senator Khan.
Yeah, well, this is our shot here, I guess. Do the sheriffs play any role in this now? County sheriffs?
Sir, the sheriffs don't play a role in the firearm purchasing. They do play a role in concealed pistol permit issuance and return of firearms that are not seized pursuant to a criminal restraining order. So for example, if a firearm was seized pursuant to a criminal arrest or was seized pursuant to a safekeeping surrender or a found firearm, prior to the firearm being released to the owner of that firearm, a background check would be done at the at county municipal level. It wouldn't come through the gun.
If there was a confiscation.
If there was a confiscation of a firearm prior to that firearm being released. And again, that's all pursuant to individual department policies. But the background would not be conducted by the gun line in that aspect. The gun line only conducts backgrounds that for firearms that are seized pursuant to a court order for domestic violence or stock.
Do you need to follow up, Senator Khan?
Yeah, is there any kind of significant staffing to this in the state? What is the staffing that's required?
The staffing levels were, I have 7 full-time staff members and 3 part-time staff members to maintain the permits and licensing mission, which consists of 4 separate missions. One of those being the gun line. The other is concealed pistol permit for non-resident issuance, return of firearms for domestic violence petitions, and counter licenses for all security guards, private investigators, bail recovery agents, or anything dealing with explosives, to include transportation, storage, and competency.
All right, so the hole that's created here, if there is no gun line, which is interesting, I mean, that's just a colloquial term, right? We never defined that in the statute, did we? Gun line?
Under 159D, the commissioner has the authority to conduct background checks. So the permission, the legislative authorization is given in that area. There is no mandate to do that. There is a memorandum of understanding that was generated back in 1998 with the FBI to be a partial point of contact for handgun purchase of commercial handgun.
And if I can follow
Yes.
Is there a delay now? I mean, can you define for us what is the time period of lag between a sale and a background check? What's that generally?
In December, we underwent additional staffing. We added additional staffing. We added troopers and some other civilian personnel we pulled from other areas to move into the gun line. We retrained those staff and we redesigned our concept of the gun line and our workflow process. As a result, basically for the last 30 days, the gun line has, for calls that come in, they're averaging anywhere from 2 to 3 minutes per check, and during peak hours, a maximum of 15-minute wait period where an FFL is waiting on the phone to submit their request. The other way that they submit requests are fax requests, and those times have been a little bit longer, but the last couple weeks has pretty much been consistent with the on-call process. The delay occurs when something goes into something requires additional research. So, for example, if you had a felony arrest without a conviction or without an open, what we would consider an open disposition, that has to be researched with the court to determine whether or not that case was either found guilty or not guilty. That requires research. Some of our research extends beyond our state borders. When we make a request, we have a requirement that we try to make requests within 24 hours of the initial delay. Once we make that request, we're kind of limited on the response of a particular agency to return that request and that information. Once that information comes back, it gets assessed, and then we determine whether it's a state prohibitor whether it's a federal prohibitor or whether it could transition to an approval status because those conditions don't.
And if one last one, relative to other states and your peers, is this is it common for the state to have a gun line or a kind of state review as opposed to using the federal systems?
That's a difficult question to answer, Senator Khan. Each state has, I can tell you in New England, Connecticut is a full point of contact, so they do all background checks for the FBI. And the state of New Hampshire is a partial point of contact. It gets a little bit more complicated in regards to state laws and how they're applied to the process. So, for example, the state of Massachusetts, there is an internal state check that's done by the state of Massachusetts that requires a permit for purchasing. So therefore, when they purchase a firearm, the background is being done as a result of it by the FBI, but they're already in possession of a state permit to which the state has done a background check. State of Connecticut, I believe has a mandatory waiting period on that, but various states have it's not as simple as an easy transition to FBI New Hampshire. Some states have more restrictive state requirements, permit requirements that are backgrounds are being done.
Thank you.
Okay, are there any further questions? Senator Whitley?
Thank you, Madam Chair, and thank you for taking my question. I'm curious about, in your opinion, whether this proposed legislation will provide the same amount of protection for victims of domestic violence and stalking, or is our current system a better way to ensure that folks who are prohibited from purchasing firearms will get flagged on a background check?
I'm not in a position to provide an opinion. What I can tell you is that the checks that are being done right now in the gun line that is involved in these checks are kind of if you look at it as the gatekeeper of deficiencies. That's pretty much all. I can't really comment in regards to whether it's going to be safer or not. From procedural, I think Sarah Freeman testified to her position or the logistics of how her business would operate if the gun line was eliminated. I think that if the gun line was eliminated, there would have to be additional considerations to make sure that public safety was addressed.
Follow up?
Follow up?
And what would those additional provisions be?
There would have to be a way of sharing the information or making the information available for some sort of review at the state level for return of firearms or domestic violence petitions that didn't have a date of birth, or that a legislation requirement that a date of birth must be obtained to get a restraining order so it could be entered into NCIs.
Thank you.
Okay, are there any further questions? Okay, seeing none, thank you very much, Lieutenant McQuaid.
No problem.
Next, we're going to call Sean List.
Thank you, Senator Carson and members of the committee. Are you able to hear me?
Yes, we are.
Perfect. Thank you so much. It's an honor to be able to testify on this important legislation. So the way that I authored this bill was based on my comprehensive understanding of both the background check system and also of the domestic violence restraining order system. Between representing firearms dealers and domestic violence victims, there's really no crossroads that's more important to me than this legislation. I want to clarify a couple of things right off the bat. that 50 to 70 names contained in an Excel spreadsheet that's being used by the gun line, that list is useless. And the reason it's useless is if you have a name, but you don't have a date of birth, then if someone calls in, say Aaron Smith calls in to get a firearms background check. Aaron Smith, the bad guy, you don't know if that's Aaron Smith who's on the list, so he gets delayed. By the way, Aaron Smith, the good guy, he also gets delayed. The NICS system was set up specifically to take state prohibitors, just like domestic violence restraining orders issued on a temporary basis. And written testimony that I already sent out to members of the committee, and you'll see a chart in that testimony containing a graph that shows state prohibitors is one type of file that is actually held by the NICS system, and we don't contribute to it. So here's where the big gap is in the current system. If we're worried about victims, well, the state gun line, they handle handguns. If they're not sharing this information like they're supposed to with the FBI, then guess what? All rifle and shotgun purchases go directly to the FBI already. They don't have that prohibitor information. So the same individual who they think they're going to deny a handgun purchase is able to buy an AR-15. It really is nonsensical. Now, I'm a member of both Londonderry Fish and Game and Pelham Fish and Game. I'm a firearms instructor. I represent gun dealers, and I'm an avid supporter of the Second Amendment. And Senator Carson, I thank you for your continued support. This bill gives an opportunity, a unique opportunity to the legislature to save hundreds of thousands of dollars to Granite State taxpayers, simultaneously while protecting the Second Amendment rights of New Hampshire citizens and making the background check system better. The whole reason that the state gun line came into existence is because back when the Brady bill was passed in the late 90s, there wasn't the federal NICS system, the National Instant Criminal Background Check system yet. So what they did in the interim is they imposed a 5-day waiting period. The way you could get around the waiting period was to set up on the state level a background check system so that you could do these transactions instantly. That's why we're a partial point of contact. So the very system we put in place to avoid delays is now causing us massive delays. The gun line, it's true, that is a colloquial term because the gun line was never created by statute. They were given authorization under 159D, but they don't have agency rules. They're unchecked. They're not subject to any sort of public disclosure. They get audited by the ATF and the FBI, but otherwise they're basically a fiefdom. The big difference between the delays we were trying to avoid in the 90s and how the gun line is operating now is we were working to avoid 5-day delays. With the gun line, it's 5 months, 6 months, 11 months, etc. It's gotten to the point where dealers really don't have any sort of confidence in the integrity of these checks. Now, people are arguing that this is a states' rights issue. I'm sure you're going to hear those arguments today. It is a states' rights issue. And for that very reason, the state gun line needs to be abolished. Right now, we are voluntarily providing funds, hundreds of thousands of dollars, and I included that data in my written testimony. We're paying that money to run federal background checks. The federal government has exclusive jurisdiction over this area. The NICS system, so the way it works is there's the III database, the NCIC database, and then a catch-all known as the NICS indices. That's where the temporary orders would be issued. This system is housed in West Virginia. It's overseen by the FBI. They do a bang-up job with it. For some reason, we are paying for this extra layer of bureaucracy that not only is denying gun owners or gun purchasers the ability to exercise their Second Amendment rights, it's failing to share the information necessary to protect victims. So our bill reverts the responsibility of running background checks required by federal law back to the FBI, like the vast majority of states that already do this. Massachusetts, New York, these are states that are ahead of New Hampshire as far as protecting this right. We are on the same plane as California currently, as far as just dishing out money for no reason other than to get the state involved in a federal process. Our bill fixes the currently non-existent due process that gun purchasers and those seeking the return of firearms property are entitled to. People have to hire me to try to appeal to the gun line when federal law says they're supposed to provide a reason for a denial within 5 days. They simply don't do that. The system that the gun line is currently using is essentially one that they've created themselves, not based on anything other than, you know, whatever the bureaucratic agenda is at the time that they're doing these checks. It's time to restore the right of Granite Staters to exercise the Second Amendment, to have due process. The federal system gives excellent due process. I know because I've represented individuals in that system as well. And to protect victims by making sure that this information is shared into the NICS databases. States like, you know, Massachusetts and New York, they have tons of state law prohibitors. And the Massachusetts licensure process is totally different than the background check process when buying a firearm. This is not a wheel that we'd be inventing. The FBI does these checks all day, every day. They do them for us with long guns, and guess what? Long guns are not an issue. The idea that we would keep the system in place that no gun dealer wants, that purchasers do not want, that doesn't protect victims is just, frankly, it's outrageous. Now, I'm happy to answer any questions that you may have regarding what records go into the system, how the gun line currently works. Of full disclosure, I'm one of the handful of people that's had the opportunity to depose individuals from the gun line, so I have a really unique understanding of how it works. And just so you know, going into the bill, we took input from all sorts of stakeholders. I was happy to hear from Sarah Freeman. I spoke to her about the bill. I spoke to the FBI. They confirmed, yes, we take this information. I've spoken with different gun activist groups. I mean, really, this bill is something that should be a no-brainer. Restore the rights of Granite Staters under the Second Amendment, stop the delays that are stealing bread from the tables of gun dealers, and allow gun owners to exercise their rights in the live free or die state. So if there are any questions, I'd be happy to answer it. And I know I've already submitted extensive testimony in written form.
Thank you very much for your testimony, Mr. List, or Attorney List. Senator Whitley has a question.
Thank you, Madam Chair, and thank you for taking my question. Have you, I don't know if you said this, but have you or Senator Guida met with the FBI to sort of think through if this legislation could be fully implemented by them, and how it would happen, how the FBI would plan to handle the domestic violence cases that Ms. Freeman, Attorney Freeman, raised the concerns about?
Yeah, those are some great questions. I'd be happy to answer that. So I have spoken with the FBI. The FBI Legal Analysis Unit, they're part of the CGIS and NICS Systems Bureau. They confirmed for me that we are already set up actually for them to receive temporary orders of domestic violence. The issue with the no dates of birth, it is true that they require either the name and date of birth or the name and social security number, which shouldn't be hard to get since these are people being served by the police, so they've been located. And the reason they require that is that's how you identify who a person is. I don't think that you could identify who an individual is, particularly with a common name, without any other information other than their name. I think that we stopped trying to do that back in probably the 1400s. But the FBI is able to take this information and add it into the NICS indices. And the bill actually requires that they be updated within 24 hours. And then at the time of expiration, or if there's a modification, that it be removed within 24 hours. So it is not, it's a, and just to try to give you more clarity, the NICS system is a virtual portal. So once you've got an authorized user, the FBI would set them up as authorized users. They would be able to enter that information immediately upon the order issuing, take it off immediately upon the expiration.
Is there a follow-up, Senator Whitley? Okay.
Did I answer
Are there
your
any?
question?
Well, I don't know if that was your personal opinion or whether you had sort of worked and met with the FBI on the issue.
Oh, yeah. So I spoke with the FBI on that issue specifically. It wasn't something that required us to like meet in person. It's I don't have an opinion as to whether or not it's a virtual portal. It just is. I've seen the system, so I'm able to say specifically that that's how it works.
Are there, Senator Khan has a question. Senator?
Thank you, Mr. List. So the previous testimony, there's a new redesigned background check that the state is using. Sounds like it's working pretty well. Have you had more recent experience? Our bills got filed and prior to December. There's a new system that's up and running. And sounds like from the Department of Safety, they've paid some attention to the concerns that people had.
Yeah, I appreciate the question. Oh, sorry, did you have more?
Well, I'll follow up with another one.
Yes, please, follow up.
No, I was wondering if Mr. List had the experience with it.
Yeah, so I do have plenty of experience. I represent many gun dealers in the state. I'm actually giving this testimony from Shooters Outpost right now with the owner of Shooters Outpost, Jim McLeod, nearby, and he's looking to testify. He can provide further information, but the 4473 form, that's the background check form that's filled out by a purchaser, and then the information is then transmitted to the FBI NICS system or the state gun line. Now, those forms show when the NICS check or the state gun line check was initiated, and also when it was resolved. I have one of those as recently as a week ago. Actually, sorry, a little more than a week ago, 10 days, resolved on February 6th, 2021, when the background check was initiated in March of 2020. Now, the FBI, they just know how to use their own system better. They have strict procedures and protocols. So yes, this is a current and ongoing issue. There are gun dealers around the state that have a backlog of inventory that, yeah, it's cleared out a little bit, but compared to, the FBI's checks of long guns, so rifles and shotguns, it really is. It's costing them hundreds of thousands of dollars. I'm sure Mr. McLeod will testify to that.
All right. Thank you.
And if I can also just actually quickly further explain. So this fix, quote unquote, fix to the issue that's been occurring with Commissioner Quinn's January memo, that has taken 8 state troopers off of the road temporarily, in addition to the 7 staff members at the gun line. And it's only a temporary basis. As I understand, there's 30 vacancies, so it's pretty strange to have 8 state troopers off the road doing these checks. But this is very temporary, and it's based upon it being an issue that's currently being discussed.
Okay, are there any further questions? Mr. Mr. List, I'm concerned about the testimony from Sarah Freeman when she talked about the emergency orders of protection, how in many instances they don't get a date of birth of the person who's they're getting a protection order from. How do you intend to deal with that issue?
Thank you, Senator Carson. So that's a great question. So as of right now, that list where they're not getting an individual's date of birth, again, that information alone is not going to be enough to deny someone a firearms transaction. So the fix is really just, if the date of birth isn't included on the petition, law enforcement needs to obtain the date of birth when they serve it on the person. So those orders don't even go into effect until the person actually has notice of them. That notice comes when local law enforcement serves the order on the defendant. If they're locating that person, they're figuring out where they live to give them an order, they certainly can supply the date of birth. And in those circumstances, having that date of birth as well as putting it into the federal system, that will ensure that both handgun transactions are blocked as well as rifle transactions, because frankly, it really isn't doing the victim cause justice to have a system set up where we may block a handgun, but we're definitely not going to block a rifle or a shotgun. It's kind of bizarre, frankly.
Okay, so I just want to make sure that I understand that you believe that it's that this would not affect an individual getting an order of protection, but in order to get that date of birth, it's going to be the responsibility of the law enforcement officer who is serving that order of protection to get the date of birth. Once, excuse me, once they get that, how is that information going to get to the FBI?
So a couple of things. These are really important questions to answer. And, I represent domestic violence victims. I teach that unit at the law school with the Dove Project. So the way it would work is this: at the time that a domestic violence protective order goes into effect, the bill language requires that it be entered directly into the NICS system within 24 hours. A domestic violence protective order that doesn't have a date of birth, that is essentially an order that's not going to have effect until they get that information. It currently does not have an effect on that person's ability to buy a firearm, other than delaying them and also delaying anyone else that shares the name with them. All of that being said, the court procedure right now, just to make it clear, for entering that information, that is not statutory. The court comes up with procedures all the time. So I would leave it to the sound discretion of the court to determine what's the best way to make sure that that information is transmitted back as quickly as possible. But even background checks for the return of firearms right now, that is not a creature of statute. That is something the court entirely set up. At the end of the day, really, the takeaway is having these names without dates of birth is doing nothing to protect victims. You got to have that information in order to make sure that even the state gun line is blocking those prohibited purchasers.
One final question. You had said that upon serving the order of protection on an individual, that the law enforcement officer would at that point get that date of birth. How is the law enforcement officer going to report back to the court that information? Is there a mechanism in order to do that?
Well, so a couple of things. The law enforcement officer would really be the last assurance of getting the date of birth. Really, at the time that these petitions are submitted with the court, the reason there's only 50 to 70 people on that list is most of the time the clerk's office says we need the date of birth for the defendant. That being said, if an officer notices that a petition doesn't contain a date of birth and they've located this person, then at that time, it could be as simple as calling the clerk's office and saying, I've got this person's date of birth. They take information like that over the phone all the time. But they should be the last stop. I mean, it's really the responsibility of the court and the filer of the petition, if they want an order to go into effect, to make sure to supply that information at the window. And this is not information that's difficult to find. I mean, if I file a lawsuit against someone and I don't include the address for the defendant, that doesn't get docketed. These are really docketed by mistake.
Okay, but what about with ex parte hearings, where it can happen very, very quickly? Do we need to look at those? I'm sorry, my dogs are barking.
No worries.
Do we need to look at that process as well?
So the ex parte orders are the temporary orders that we've been talking about.
Right.
So as soon as a defendant has due process, then it becomes a 1-year order. So that's really what we're talking about here. When those orders are issued on an ex parte basis, frankly, most of the time it's based on the urging of law enforcement that the person should go file one of those orders. If that's the case, when the petition is being filled out, a date of birth should be included. If the petitioner doesn't know that date of birth, that's something that law enforcement can obtain very easily.
Okay. Okay, now what I'm concerned about is any delay in information in a domestic violence situation. And I want to make sure that we've covered, that this legislation would cover all the bases on that.
I couldn't agree with you more. It's something that's near and dear to my heart, as most of the people that work in the field know about me. It's something I volunteer a significant amount of time doing. The thing is that we want to make sure domestic violence victims get relief as quickly as possible. There is still certain information that we need in order to accomplish that. Having a list that's been thrown together and is rushed, but doesn't actually accomplish the purpose of denying the person a firearm, that does not serve the ultimate objective. It'd be better to take the additional 20 minutes, get the date of birth so that it's actually effective, and share this information into the FBI NICS system so that it blocks rifle purchases as well. That seems to be the most comprehensive way to make sure victims are protected.
Okay, all right, thank you. Are there any further questions from the committee? Okay, seeing none. Thank you very much for your, excuse me, Senator Whitley has a question.
Well, I'm just wondering if it's not a question, but before we hear from the next person, I wonder if we want Attorney Freeman to come back and sort of speak to the feasibility of implementation.
Okay, all right, what I'd like to do is to try to get through the list before we get other folks. I don't even know if Attorney Freeman is even available. Can you look, Margaret?
I guess I was just thinking while we were sort of talking about this implementation issue, it might be good
Okay.
for the courts.
He is available.
Okay, why don't we go back to Sarah Freeman to answer Senator Whitley's questions.
I'm on.
Thank you so much for coming back on, Attorney Freeman. And thank you, Madam Chair, if I may. I don't know if you've been hearing the testimony about, how this implementation would work. And I'm wondering if you could speak to, what this would look like in reality. It sounds like this implementation would fall to the courts. Is that feasible? What would that look like?
With respect to the other state disqualifier indexes that Attorney List was speaking to, I don't have any understanding of what that process looks like, and there doesn't appear to be legislation that would set that up. So I'm not sure how that transition would work if we were trying to put some of these state prohibitors into the FBI system, because I haven't seen that process and I can't speak to that. I can speak to the fact that the DV orders that don't, and stalking orders that don't have dates of birth, they are accompanied usually by other identifiers. So Gunline does have the ability to make a decision to delay an order of gunline purchase based on an order of protection, because they might see that there's a height, weight, address related to that order of protection that may match that person's application. And we do occasionally get dates of birth back from law enforcement. That information is given to us on a return of service that is faxed from local law enforcement to the courts after an order has been served. There can be delays of days, weeks to get that information into the system, especially if an order of protection is served out of state or is served by a small police department that's only part-time. They may not get those orders, those returns of service to us quickly. So I guess those would be my, that would be my follow-up to Attorney List's statements.
Thank you. That's helpful.
Okay, does anyone have any questions for Ms. Freeman? Okay, seeing none, thank you very much. We're gonna call Evan Knappen.
Unmute. Okay.
Good afternoon, Mr. Knappen.
Good afternoon to all the members of the committee, and thank you for letting me speak. I am an attorney. I've been practicing in the area of I call gun law for over 30 years. I have a multi-state practice both here in New Hampshire and in New Jersey. I wrote the book New Hampshire Gun Law, and I've focused on this area for my entire career. And I'm here today in support of this bill, and I would like to just bring a few things out, although a lot of great information has already come out. And that is the origination of why we have the gun line is because of the Brady bill. The Brady bill initially had a 5-day waiting period, and New Hampshire, always respecting the Second Amendment, did not want to impose a 5-day waiting period. So what the Brady bill said was that if a state created their own instant check system for handguns, then the waiting period under federal law would not apply to that state. So New Hampshire adopted its own instant check, which was to run the 5-year period in which there was a waiting period under Brady until the national instant check system became online, where an instant check could be made by making a call into the FBI and into the NICS program, so that there was no need for a waiting period to do a background check. And so the idea at the beginning was to avoid waiting period and then get the national instant check system as what will be universal through the United States. But what happened was there was frankly politics involved in different agencies at the time. Certain folks wanted to maintain the instant check system, and there was a legislative and political fight that took place, and New Hampshire ended up in a kind of an odd position. New Hampshire ended up bifurcating the system, where we had originally done handguns only, and there was a push to do everything as a what is called a POC, and we should really, that means point of contact for the NICS system, to be a full POC. And others say we should not be any POC and that just let the federal government handle it. And we ended up bifurcating it so that handguns ended up staying, pursuant to this agreement that we followed up with the feds, as a point of contact check. Long arms, rifles and shotguns are not a point of contact check. New Hampshire is a point of contact, which means that New Hampshire pays with taxpayer money to do what the federal government will do for free for us. And the problem is that the federal government does it so much better than our state does. When you call the federal gun line, this is the Fed's own statistics through NICS, 93% of the time, that instant check over the phone will either be approved or denied. 93% of the time, the national instant check is in fact instant with the federal NICS gun line, the federal line. But in New Hampshire, I'm sorry to say, I'm actually not aware of a single incident personally I've ever heard of where it was instant. Now, if it ever was instant over the phone, that is absolutely the exception, not the rule. And you will hear, I'm sure, from other folks in the firearm business as dealers and all that will tell you about just how many delays and how long these delays go on for days. And yet the whole purpose of it was not to have delays. And yet that's what we're facing, serious delays. Someone had asked a question before about of Sergeant McQuaid about how many states operate like New Hampshire and are a POC. I have the actual numbers for you. This is from the NICS participation map. It is put out by the Department of Justice Federal. You can go online through their NICS and you can just Google NICS participation map, and you'll be able to see what I'm going to tell you now. There are 36 states that are not POCs. In other words, there are 36 states that let the federal government pay to enforce a federal gun law, and they do not burden their taxpayers with having to pay to enforce a federal gun law. There are 13 full POC states. 13 states do all of it themselves and pay for it as a point of contact. Now, New Hampshire, as I said, is a partial. We bifurcate. There are 4 states that are partial states, like New Hampshire, for handguns, and then long arms go to the federal gun line. There are 3 partial POC states in which they're partial because it's used for state-issued handgun permits. And that's why they utilize their own state system as well and can become a POC. But those are the numbers. Just imagine there are 36 other states that have the federal government pay to enforce its federal law. This is not a state law. This is a federal law. And that brings up something that has not been discussed, but I know has been talked about and may come up. And that is, there is a question here about federalism. There's a question about states' rights. Now, some folks have heard argue that, oh, this is good for states' rights, that we are a POC. But nothing could be further from the truth. And a matter of fact, the history of this on the Brady Bill itself is landmark in the movement for states' rights. And the case is Prince versus U.S. and Mack versus U.S. Both Prince and Mack together were sheriffs who sued the government over the Brady Bill's imposition of forcing sheriffs to do background checks. And they said, you can't make a state pay to do what the federal law has enacted that the federal government is supposed to do. You can't make us do that. And they won on 10th Amendment. They won on that. And the United States Supreme Court said you cannot force a state to pay for background checks via a federal law. So here there's this win specifically on the Brady Bill that establishes states' rights and makes it clear that you can't force a state to pay for background checks. And yet, what does New Hampshire do? Well, we voluntarily pay for it. Boy, that's pretty foolish. Why are we voluntarily paying our tax dollars to enforce a federal law? We shouldn't be, especially when the federal government does a great job at that. And boy, can you imagine even saying that? They actually do something well? Well, they do. They do the NICS extremely well. They actually try to make the National Instant Check an instant check, whereas the state of New Hampshire does not. And individuals are being denied their rights. In terms of federalism, look, just imagine if instead the federal government passed a law that said that before you get to purchase any type of device that can access the internet, be it a computer or a smartphone, you need to do a background check. And look, it's because people commit crimes on the internet. There's, scams and thefts and child pornography and black market. And, we really want to make sure before just anybody accesses the internet that if you're going to get a device that does that, we just want a background check. Now, of course, this is offensive to the First Amendment. I think most of us would see that as offensive to the First Amendment. But if the federal government mandated it and this was law, would New Hampshire then say, hey, we want to pay so we can help enforce this federal law that, yeah, it's offensive to the First Amendment, but so what? It's a federal law, and we want to make sure we pay for that with our tax dollars, even though the feds will pay for it ourselves. That's the type of federalism we're talking here. New Hampshire should not be spending its tax dollars to enforce a federal law that the federal government is willing to do and, in fact, obligated to do. And we have no obligation to do it. And there's even case law that established the lack of obligation as an enforcement of the 10th Amendment for states' rights. Thank you for your time.
Thank you very much for your testimony, Mr. Knapp. And are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
Next, we're going to go to Lauren LePage.
Good afternoon. Can everybody hear me?
Yes, we can.
Okay. I'm going to refrain from reading the written testimony that I've submitted in strong support of Senate Bill 141 because most of what's in that has already you've already heard speakers who are supporting the bill. So I'll save the committee a little bit of time. But I do just want to say that this bill authorizing the FBI to conduct all NICS searches is incredibly important. It will reduce delays. It streamlines the background check process. It will save taxpayer money, all things that we've heard before. And I just want to reinforce how common it is for states to allow the FBI to conduct all of their background checks. The gentleman before said 36. According to the ATF website, it's 32 in the District of Columbia, but certainly the vast majority of states are doing it this way, including Maine, Vermont, Massachusetts, New York. The vast majority of the Northeast is doing it this way. So with that, I would just like to express our very strong support on behalf of our members in New Hampshire and urge the committee respectfully to support the bill.
Okay, thank you very much for your testimony, Ms. LePage. Are there questions for Ms. LePage? Okay, seeing none, thank you. Next, we're going to go to Jim McLeod.
Mr. McLeod, I do not see your name. If you could virtually raise your hand. Sean List came up, but.
Okay. If he shows up again, we'll call on him then.
Okay.
We're gonna go ahead and call Jason Major.
Senator, I think that Jim McLeod and Jason Major are with Sean List at the same location. So they have one connection between them.
Okay. Well, maybe the two of them if he talks, we'll let the other one as well.
Okay.
So,
Sean List in.
yeah, go ahead. See if Mr. McLeod is there.
He is here, and that's why I was raising the hand over and over. So, Mr. McLeod's
Okay.
here.
Okay, great.
Thank you, Madam Chairman. I've been a gun dealer for many, many years. This isn't just financial to me, but it is financial. So a lot of people have agendas here. One of them is definitely financial, but the other ones, I have a lot of customers. And I have a lot of customers that walk in the door, they want to purchase a firearm, and they're delayed time and time again by the state of New Hampshire. Now, they can go out and they have come back and said, well, I went down the street and I bought a shotgun, but I'm still delayed on this handgun, which Attorney List testified to. That is ridiculous. I mean, if you don't think a shotgun is dangerous, then you've probably never been in front of one or behind one. But the financial part, and the Lieutenant McQuaid, I believe he's a lieutenant now, not a sergeant, but Lieutenant McQuaid testified that it got better. It was so bad by the time that we brought this subject up that I had over 150 guns sitting on a rack on delay waiting, with only a few people working the gun line. When this became an issue and 8 state troopers joined the crew at the gun line, and my tax dollars are paying for these state troopers, and I would like to pay for them to be on the road, not doing background checks, sitting in Concord. But Lieutenant McQuaid paid attention. He brought those troopers in. It did get a little bit better, but it wasn't instant like it's still supposed to be. Sometimes it would take hours. Sometimes it would still take days. Sometimes the gun line wouldn't even answer the phone. So for an entire day. And there's other gun dealers that can testify to that. Now, no gun dealer wants firearms to be in the hands of bad people. You know what? We all work hard. We all care. We turn down a lot of our own sales for people that, quite frankly, when I teach my people how to sell a gun, I let them know if you don't feel comfortable in public with that person in front of you, you don't sell the gun. So we all care. Every gun dealer does. We also have the right to release firearms after 3 days if they're on delay. Very few gun dealers do that because we do care. If there is a legitimate delay, we don't want those firearms in the hands of those people. So a lot of you probably don't understand it. We can transfer after 3 days if we don't get a resolution back by the state gun line. We don't care to do that. We don't want the liability, and we don't want our families in public if that's a legitimate delay. But when I have people coming back saying, why am I delayed? I just got a handgun permit, because in the state of New Hampshire, you can either get a permit or you don't have to have a permit to carry concealed. I just went and got one from the city of Manchester or the town of Bedford. Why can I get a handgun, a license to carry a pistol revolver, but now I'm delayed to buy one? So it doesn't make sense. We pay for this service with the federal government. And I'd be the first to tell you, I hate saying that the federal government is doing a much better job than the state of New Hampshire, but they are. So if we can iron out the details about getting these 50 to 70 people and date of birth or social security numbers, I mean, bingo, we're going to solve this thing and save the state of New Hampshire a lot of money. A lot of other things were said by the people that have already spoke before me, so I kind of had to weed a lot out, but that's the gist of it. The gun dealers care. We do tens of thousands of guns a year. The other thing that wasn't said is when someone is delayed, I'm in Hooksett. So there's a lot of people traveling through Hooksett to go to the North Country, that come over from Keene, come over from the Seacoast. And when we call them back after a few days by getting a resolution by the gun line, they said, never mind, I changed my mind. So some people would say, well, big deal, you still have the gun to sell. Well, that's not true. Well, I do have the gun to sell, but I took an hour of an employee. We employ 35 people at Shooters Outpost with 2 locations, right? I've spent an hour with that employee with pay and benefits selling that firearm to begin with, to have a person say, I'm not driving back over there from Seabrook or Keene or Peterborough, and I don't blame them. But the system is broken. The system needs to be fixed. And even trying that in the past couple of months, Lieutenant McQuaid worked hard to try to do it, but it still wasn't where it was supposed to be, not even close. But thank you, people. Thank you all, and I hope you consider passing this bill. It's needed, and with a little bit of work, we can get it done right. We can keep the people safe, and that's what every gun dealer wants. I can speak for every one of them. There's no one that wants a gun in the wrong hands.
Okay, thank you very much for your testimony this afternoon. Are there any questions from the committee?
No, Madam Chairman, thank you very much.
Okay, seeing none, thank you. Next, we'll go to Jason Major.
Jason, I did not see your name on the list. If you could virtually raise your hand, and if you are on the phone, you can press *9.
I think he's with Sean List as well.
Oh.
Okay, let's go back to Mr. List, and let's see if Mr. Major's with him. Mr. List, is Mr. Major with you as well?
This is Mr. Major. Can you hear me?
Yes, we can.
Okay. Thank you, members of the committee. I'm a practicing attorney. I'm actually a law partner with the author, Sean List. I'm pretty sure I'm one of a small handful of lawyers in the state who identify as true conservatives. Like Sean, I have long-standing attorney-client relations with several gun dealers in the state, most particularly Manchester Firing Line Range and Shooters Outpost under the ownership of Jim and Carrie McLeod. I've been doing that since 2003 or so. Part of my practice involves coaching clients through the process of obtaining firearms regulated by the federal National Firearms Act, which is a whole other level of regulation imposed by the federal government. And like Sean, I've taught continuing legal education classes on a variety of topics related to firearms ownership and use. I'm not a mere theoretician when it comes to the Second Amendment or gun-related issues. I'm well trained on the legal side, but also the practical side, and I'm an active practitioner of my rights under both the state and federal constitution. My involvement in practice with gun owner and gun dealer related issues, both personally and professionally, I think gives me a better than average insight into some of the issues that SB 141 is seeking to address. That said, I'm not going to go back and echo all of the technical stuff that Senator Gaida, that Sean, that Attorney Evan Knappen have said. They did a good job. I think in particular, if you look at Attorney List's written materials, which I've looked at, there's very good explanations of why this bill needs to pass in there. A few of the highlights, though, you know, a 27% error rate on information entered into the gun lines database. That's unacceptable. Delays up until this point of days, weeks, sometimes months. I understand that there's been an effort to fix that, but how politically motivated has that been just over the last month or two? That's unacceptable. The lack of due process for people who are denied, the inability to get a simple solution like the NICS system offers to get your name off a denial list. That doesn't exist in our current system. The concept of transfers on delays, as Mr. McLeod testified, most dealers are not going to do that, but there are some who can't afford not to. And when that happens, you have a situation where there's a gun out there in the wild that may be with a person who's not supposed to have it. And so in that case, what's the dealer supposed to do? He's told, go get the gun back. How does he do that? Even assuming he's successful in getting the gun back, you know, that's time and money out of his pocket. That's a lost sale to someone else that he should have made. And if he doesn't get it back, what are the consequences there? A crime? That's unacceptable. One comment I did have about the gun line and this idea of domestic violence petitions. It's my understanding, and it may be clear in Attorney List materials, that the gun line only asks for name and date of birth, whereas the feds, the NICS system, asks for more identifiers, including height, weight, hair color, eye color. They have a more thorough system of gathering information in the first place. And if our law enforcement officers are instructed to get that information and provide it to the system, as Sean said, I think that fixes that problem. My comments, though, really, I'm looking at this as a conservative voter. For myself and other like-minded citizens who, when we cast our vote for a candidate with an R next to their name, we're voting for smaller, less complicated, more efficient, more responsive government. I think Attorney Knappen touched on this a little bit. There's this sort of idea, some people who don't understand the issues maybe as well as they should, that having a state gun line somehow gives a unique New Hampshire perspective. It's a states' rights kind of thing, that we can somehow take over this role, supplant the federal government. And I think it's already been made clear that's just not so. The idea that the federal government would not be involved in each and every firearms transaction conducted by dealers in the state is a ship that sailed in 1968 and it disappeared over the horizon with the passage of the Brady Bill in 1994. The federal government's going to be involved in every transaction of a firearm through a dealer, and having a New Hampshire specific point of contact doesn't change that. It's really just more government on top of the federal scheme, which already regulates those transactions. We're using New Hampshire taxpayer money to enforce federal law that the feds are more than happy to enforce for us without us having to pay for it. When I cast my vote as a Republican, like those other voters who gave this legislative body a majority, a Republican majority, we did it to get that smaller, less complicated, more efficient government that the Republican Party touts as part of its platform. For me, in addition to the gun owner reasons for wanting this bill to pass, and the lawyer representing gun dealers' reasons for wanting this gun to pass, as a Republican conservative, SB 141 is all about delivering on the mandate that we gave the Republican Party to deliver us less complicated, more efficient, less costly government. Gun line's just extra, unneeded, inefficient complication of bureaucracy. It's the opposite of what we vote Republican for. and it's doing more harm than good. So the statistics provided earlier, provided in Attorney List materials, they tell the tale. This thing isn't working. Some last minute attempts to make it work are probably temporary. And once this political issue goes away one way or the other, those temporary fixes would go away as well. And right back to where we were a few months ago with wait times in weeks and months. I've seen the room here at Shooter's Outpost where Jim McLeod keeps these delayed transactions. At one point he had 6 figures worth of guns in a room on delay. He's a big operation. He can kind of handle that for a while, but when you think of the local mom and pop gun store, they can't. At some point, those transactions have to go through, and that's not what we want. Let the feds do the job. They do it better than we do. We're already paying them through our federal taxes to let them do it. Why pay it twice to get a product in the end, which isn't as good? So I would say pass SB 141. There's no reason not to. I think the domestic violence concerns have been addressed by Attorney List, and there's no reason not to do it. So please do the right thing on this bill. And I appreciate you taking some time to listen to me.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to go to Patrick McCarthy.
Patrick, I do not see your name on the list. If you could virtually raise your hand, and if you are calling in by phone, please press *9. Senator, I do not see Patrick.
Okay, let's go to Jason Janvrin.
Thank you, Senator, and good afternoon to the committee. I just want to make sure.
Mr. Janvrin, before you get started, we've had a lot of testimony this afternoon. What we're interested in hearing something new. So I'm going to ask you please to not repeat the testimony that we've already heard.
That's quite fine, Senator. I don't think you recognize my name. I served 4 years on the House Judiciary, so I think I'm pretty good at this. I only want to touch base on a personal note. I'm just going to give you some dates here, and I hope that you would keep this in mind. On January 17th, I traveled to Kittery Trading Post with my son and my grandson to purchase a pistol. On January 18th, I had to go back to the New Hampshire location and fill out a 4473 for the state check and for the federal check. The Kittery Trading Post told me at that time, be prepared because the state police are going to delay you. On the 20th, I called them, and true to form, state police did delay the transaction. On January 22nd, I emailed them at permits and licensing at dos.nh.gov and got no reply. On February 1st, I called Kittery Trading Post and was told that I was still in a delay status by the state police. I called the gun line, the civilian side of it, and used option 4, which is for those who are delayed or denied, and left a message asking them to return my phone call. On February 1st, I also emailed them, and I CC'd Senator Guida so that he was aware of what was going on. On February 16th, just today, I called Kittery Trading Post. This is now day number 30. I am still in the delay by state police. I also emailed the Department of Safety, and I'm still not getting any responses. I'm getting no decision, and I'm absolutely getting no reply. So I did want to point out in my testimony that, as we know, pistol permits require a decision within 15 days. Background check for pistol purchases, if you go by the statute RSA 541A29A, the state police have up to 60 days to give me a determination. And I'm really not willing to wait 60 days to exercise my constitutional rights. And I thank the committee for hearing my testimony today, and I will take questions.
Thank you very much for your testimony. Are there any questions from the committee? Right. Seeing none, thank you again.
Thank you, Senator.
The chair will call Kevin Wiley.
Mr. Wiley, I do not see your name on the list. If you could virtually raise your hand or press *9 if you were calling in by phone. Senator, do I not?
Nothing? Oh, okay. Next, we're going to go to Brian Mayette.
And Mr. Mayette, if you could please virtually raise your hand or press *9. Senator, I do not see Mr. Mayette.
Okay, let's go to Lawrence Keene.
Hello. Can you hear
Okay,
me?
yes, we can, Mr. Keene. Mr. Keene, before you get started, I would just like to ask you to be cognizant of the time. We've had a lot of testimony on this bill already, and so we are interested in hearing information that we have not heard before.
Thank you, Senator, and members of the committee. My name is Lawrence Keene. I'm speaking as a private citizen and a resident of New Hampshire, but I am also the Senior Vice President and General Counsel for the National Shooting Sports Foundation, which is the firearms industry's trade association. Our members would include Sig Sauer, Ruger, and many firearms retailers licensed in the state of New Hampshire. I personally support this bill, and I know NSSF has submitted testimony in support as well. For several reasons, and I will not belabor what has already been stated, but this will allow our fellow Granite Staters to exercise their fundamental civil liberties protected by the Second Amendment without undue delay. This will save taxpayers money by removing redundancies that can be performed more efficiently and for less money to the state by the federal government. New Hampshire is one of only 4 partial point of contact states in the nation. The vast majority of states in the country simply have NICS perform the background checks and do not incur these costs to the taxpayer. There is no degradation of public safety by having the background checks performed by NICS. The exact same databases are searched by NICS as are searched by the gun line. There was a comment earlier that we don't submit from the woman from the court system, we don't submit the records to NICS. That is correct. The records go into the databases that are maintained by the FBI CJIS and are accessed by NICS. This would also obviously benefit small businesses, as you've heard across the state, who would be able to make transactions lawfully and not lose the opportunity to make a sale because people get frustrated by the very lengthy delay that you have heard about. Lastly, I do not believe it's accurate that the state cannot submit temporary orders of protection to NCIC simply because they don't have the date of birth. And as was mentioned earlier, the NICS system, the 4473, the consumer fills out, has much more information like the pedigree, age, height, weight, as well as requesting the social security number, which is a better differentiator than a date of birth. And if a name matches a name in the system, even if you don't have the database, that would cause a delay and an investigation by NICS to sort out whether the person was prohibited or not. My last point, I would encourage the state, because it is rightly concerned about public safety, that the state ought to be reporting to the NICS system, to the databases, the disqualifying mental health records, which the state is currently not doing, is one of only 3 states in the nation that does not report these disqualifying mental health records to the federal government so that they are in the database. So if a person purchases a firearm in New Hampshire or moves to another state, those records will be in the system. And they currently are. And there's legislation been offered by our organization called Fix NICS. And I would encourage the legislature to take a serious look at that legislation, because that's the real hole in public safety in the background check system. Thank you very much for your time, and happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Thank you very much, Mr. Keene. Next, we're going to Trevor Santos.
Madam Chair, for the sake of time, Trevor Santos with the National Shooting Sports Foundation as well. I'll just refer you to the written testimony I have submitted because Mr. Keene has touched on all the points. Thank you.
Thank you very much, Mr. Santos. We have received that testimony and we will make sure to review it. Thank you. Next, we're going to Richard Feldman. Good afternoon, Mr. Feldman.
I think after listening to all the testimony this afternoon, everything that I think is relevant, I've already heard, so I don't wish to take any more of the committee's time. We are, of course, in support of this legislation. Thank you very much for your consideration.
Thank you. Thank you very much, Mr. Feldman. Next, we're going to go to, let's see, Alan Rice.
Good afternoon, Madam Chair. Can you hear me?
Yes, we sure can, Mr. Rice. I'm going to remind you, like I've asked a lot of folks, we've heard a lot of testimony on this issue this afternoon. We are interested in new information, so if you've got something new to tell us, that's great.
Yes, I appreciate that. I will be very brief, Madam Chair. I'm Alan Rice, representing Gun Owners of America. I have submitted some detailed written testimony to the committee, and a lot of previous speakers did a fabulous job of explaining the problems and the delays that the gun line is experiencing. I just want to call the committee's attention to the 1999 law that authorized the permanent provisions of the gun line that exists today. And when I review that legislative history, the public was overwhelmingly opposed to making the gun line permanent and not allowing the FBI to do the job. Today, the public is overwhelmingly in support of transferring it to the FBI. So the public has been consistent. And I would ask this committee and the entire Senate to vote Senate Bill 141 ought to pass. And I would refer to my written testimony. And I thank you.
Thank you very much, Mr. Rice. We will definitely look at your written testimony. Next, we're going to go to Jay Simkin.
Mr. Simkin, if you could please raise your hand virtually or press *9 if you were calling in on the phone.
Hello?
Good afternoon, Madam Chairman and members of the committee. Can you hear me?
Yes, we can.
Very good. Most of what I have to say you will not have heard. There appears to be an implicit assumption on 2 points. One, that if a person is properly denied, that they will not get a firearm. At the end of 2018, there were about 423 million firearms in the US, excluding military items. With that number of firearms available, the small minority of those who are denied, if they are truly determined to get a firearm, will get a firearm. By way of background, I've held a federal firearms license since mid-1983, and since mid-1993 have been domiciled in New Hampshire. I do background checks personally, so it's not, quote, one of my employees. Further, to the question of the efficacy of background checks, a Government Accountability Office report, which I will include part of with my testimony when I submit it, shows that of 12,000 denials in 2018, only 12 federal prosecutions resulted. So the idea that background checks are this magic preventative is simply not so. Now, as to the issue immediately at hand, I oppose Senate Bill 141. It should be deemed inexpedient to legislate. The core problem with these long delays is that for a period of years, there has been a Department of Safety in a position of responsibility, an employee whom I would describe as rogue. This employee reshaped the background check process to be proper as she defined it, and therefore did things that the feds, the FBI NICS Center, did not do and does not do. And that is the reason for these long delays. I believe Department of Safety at last has curbed this rogue employee. And now background checks from Department of Safety take about the same time as those done by the FBI NICS Center, about 5 minutes from start to finish. Those who represent these checks as, quote, instant, end quote, mislead. The reason being that it obviously takes a couple minutes for the dealer to relay to the reviewer the personal information about the buyer. Indeed, there have been statements made to the committee today by attorneys who, if they made such statements before a court, would put their law license on the line as a result of not being entirely honest with the tribunal. Their statements are such that they can't be accidental. I'll give you an example. The FBI NICS Center requires dealers to see documentary proof of a buyer's full legal name. Most New Hampshire state-issued IDs have only a middle initial for a person who does have a middle name. So therefore, when I submit to the FBI NICS screener a request to approve a transfer of a rifle or a shotgun, my customer sometimes has to dig up a birth certificate copy to show to me so that I can honestly state to the FBI screener that, yes, I have seen proof that the middle name put on the form 4473 is, in fact, the applicant's true legal name. The New Hampshire Department of Safety doesn't impose that stricture, so that they ask, what is the applicant's middle initial? Apparently that suffices. Second, those who support this bill apparently do not know, or if they know, withhold from you, that the FBI NICS Center often delays those who hold or have held certain security clearances. For example, Navy SEALs, members of other special operations units. Most of the NICS agents are contracted employees, and they cannot view the records of those who have served in special operations units or have held other high-level security clearances. If there isn't anyone in the NICS Center with an adequate clearance, that person's delayed. They are no doubt entirely law-abiding, but delayed they will be. I point out that after 20 years of war in Southwest Asia, many, many more folks have held such clearances, some may be delayed by FBI NICS. That is not the case with Department of Safety. Those folks get processed the same as anyone else. I'm also told that Department of Safety, unlike FBI NICS, is quick to give the precise reason why a person is delayed or denied. This precision makes it easier for a person to find records that are relevant. For example, a court docket number and the date of an alleged arrest or appearance before a court. I gather that the FBI NICS Center is far less helpful. For example, they require all contacts to be by letter. Department of Safety accepts some documents by email, facsimile, or even hand delivery. Some of the attorneys who have addressed you today have led you to believe that almost all inquiries to the FBI NICS Center get instant approval. Not so. 70% get instant. That means 30% don't. My source for this is the NICS Operation Report 2019 pages 21 and 22. That said, most of those who are delayed by NICS get a resolution within 3 days. So, unlike many who have testified here, I am precise about information. Those who have testified would have you believe that dealers often have to retrieve firearms. The 2019 NICS Center report states that for the 30 plus states with which they're concerned, 2,989 required law enforcement to retrieve a firearm from those to whom it was transferred, and then the transferee was later determined to be prohibited. Now that's 3,000 checks, possibly more than that number of weapons, for 30 states, millions and millions of background checks. So the idea that has been conveyed to you that licensees in New Hampshire spend a lot of time retrieving weapons, which they transferred because they didn't get a timely response, or they got an approval that turned into a denial, is not likely to be true. I can't tell you how many unfortunate or inopportune transfers occur in New Hampshire, but if it's 3,000 for the 30 states nationwide in 2019, hard to imagine it's more than 10 or 15, maybe 20 in New Hampshire. A dealer who can't afford to take a hit, getting back a used gun, ... probably shouldn't be a dealer. And in any case, if in that situation, there's no requirement that the dealer give the buyer who lied on the 4473 a full refund. If someone lies to me and thus to the feds or to the Department of Safety, they don't have a legal right to tell me, well, Simpkin, you sold me a weapon that cost $800 and you're only going to give me $700 back because I'm prohibited, but I took it to the range and used it. Good luck to them. I'll see them in court. The other thing that the FBI NICS lovers haven't told you is that 2 to 3 years ago, the FBI NICS Center slashed the number of phone center agents. The result was long hold times. I suspect, I do not know, that reduction in the number of phone agents was intended to push dealers to use e-check. E-check operates around the clock. Well, I would point out to the members of the committee and everyone else who listens, there is now in Washington a new administration that can honestly and fairly be described as militantly anti-gun. Thus, they could, with a stroke of a pen or a few keystrokes, slow down all inquiries to the FBI NICS Center. So they wouldn't turn off the databases, they would maintain those, but they would simply slow down e-check and slow down phone checks. If we have the gun line can still access those databases, NCIC, III, et cetera, and give us a response. Further, something else that hasn't been pointed out to you is that e-check, the FBI NICS online background check system, requires information to be sent, quote, over the internet. Some of you may be aware, and I hope all of you are aware, that there has recently been a huge hack of major corporations and government agencies' databases. Google SolarWinds Orion, ORION. Anyone who claims that databases are secure is delusional. And thus, it is lunacy to shift all background checks to FBI NICS, which plainly wants all of this to be done online. For the while, they maintain phone access. But I suspect before long that will go away. And they will make the same case that has been made to you. Well, we want to save money. You can have it fast and you can have it cheap, but you can't have it good and have it secure. So in short, phone access is more secure for the wild, and we ought to maintain it for as long as we can. Bottom line, Department of Safety seems to have come to grips with the problems that inspired Senate Bill 141-FN. That bill, no matter how tweaked, will harm New Hampshire firearm owners. As a licensee, I'm exempt from background checks. I don't have a horse in this race. I want what is best for my customers. And what's best for my customers is keeping background checks under state control. This would have been true even had Mr. Trump been reelected, but with someone now in the White House who has a decades-long record of anti-gun activism, the shifting of background checks to the federal authorities is worse than lunacy. It is criminal. I'll be happy to take any questions that the members of the committee have for me, and I thank you for this opportunity to testify.
Senator Carson, you're on mute.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none. Thank you very much.
Thank you much, Madam Chairman.
Margaret, I've gone through the list. Are there folks in the waiting room that would like to speak?
Yes, we have Penny Dean and Robert Clegg with their hand raised.
Okay, let's go to Penny Dean, please.
Yes. Hi, members of the committee. My name is Penny Dean, and I'm an attorney, and I've mentioned before my qualifications, my attorney qualifications before, but I would also mention that I have shooting qualifications. In addition to being a licensed practicing attorney, I also have graduated from LFI 1, 2, and 3, and I'm also an NRA certified instructor in several disciplines. And I am opposed to this bill, strongly opposed, and I would ask that you ITL it. And here's what I would respectfully say to you. Courts say all the time there's different qualities of testimony. When they are weighing testimony of different individuals, they look at the quality of the testimony, the education, training, and experience of those offering the testimony. And I would say to you that I'm an attorney licensed in New Hampshire for over 20 years, having done all of this type of practice of law. And I would argue that I do have a comprehensive understanding of the system. And this system that they're talking about going to, the NICS system only, would absolutely be a detriment to New Hampshire taxpayers. And I want to answer a question that I do not believe has been answered correctly and truthfully, that's been asked by members of this committee first. And number one, they ask about the domestic violence petitions and putting them in the system. And here is what I respectfully suggest that the committee look at. If you look at 18 USC 922 G as in George 8A, I believe it will answer the committee's question. I do not believe the federal government will enforce state law. And here is what you have here. Most of the temporary domestic orders that they are talking about that get entered in the system are temporary orders. In order for the feds to bar someone, there has to have been, under 18 USC 922 AG 8A, it has to be subject to an order that was issued after a hearing at which the person who received actual notice and which such person had an opportunity to participate. The domestic violence orders that they're talking about, the temporary DVs, the ex parte DVs that they're talking about, I do not believe federal law is going to enforce those. And I certainly don't believe that federal law is going to enforce state law in that specific area. I would be shocked to see if they did. So that answers one of your questions. Another of your questions, which I think is even more important, and the largest important thing, is constitutional rights don't always have price tags. And my mother used to say, if everyone else is jumping off the bridge, are you going to jump off the bridge too? What other states do is interesting, but not material to what New Hampshire does. And New Hampshire has chosen to keep the gun line because we care about our civil rights. Now, if this bill were to pass, I'm going to make a whole lot more money. A whole lot more money. And here's why. Depending on whose data you look at, if you look at FBI data, if you look at Reuters data, if you look at ACLU data, approximately 25% of Americans have criminal records. And every person that I tell that to, they think that's an astounding number and that can't be correct. And I respectfully suggest you Google it. You will find government agencies and all sorts of entities that they might say it's 22%, some say it's 26%, but it's in that neighborhood. Now, all of those records do not disqualify a person from owning a gun, but they still have these records. And here's why this is important. And I want to walk you through the mechanics, something no one has done to date. And I think this is hugely important for my clients. If you go to a gun store and you try and buy a handgun and you are put on delay or deny status, they will give you a number, an individual number for your name. You can then drive to Concord, walk into where we call the gun line, which is the old DMV building, show the person your ID, and the people at the gun line will give you an answer on the spot, or you can hire an attorney like me and sign a release and do it. And they will say to you, Mr. Smith, you were convicted in Concord District Court in 1992, June 4th, and here's the docket number, and this is why we're denying you this purchase. That allows you, the person who's been denied, who may be a woman who's afraid and who needs it to protect herself against maybe a newly abusive person, all sorts of things like that. It allows you to go to that information and say, gee, there's a mistake in this record. You can then walk, fax, email, walk back into the gun line and say to the person, here's this data. I'm not a prohibited person after all. There's been a mistake and I'd like you to review this data. It's been my experience, and I don't want to use the word never, but I've been licensed to practice in New Hampshire for over 22 years. And when I email the gun line a release from a client that says this client's been denied, usually I get an answer the same day as to why. I don't want to say I've never waited more than 24 hours, but I don't recall in recent, probably the past 10 years, waiting more than 24 hours. That's a huge, big deal. Now, if that same person walks into a gun store and tries to buy a long gun, they're going to get, and they get delayed or denied. Let me tell you what happens next. And remember, you're a person who may be afraid for a variety of reasons, who may be facing an abusive spouse or neighbor, and it's your first gun. You don't have 5 others at home to save you. So remember, you're paying an attorney by the hour. So you've paid me very efficiently to go to the gun line, find out why, specifically why, and get an answer that we can debate. If you're denied on a federal level, you give me, again, an NTN number. I have to mail that letter to the feds. Now, you have to go get fingerprints taken and all sorts of other things. And you say, wait a minute, I don't have to have fingerprints to get a passport. I don't have to give them fingerprints to do anything. Why do I have to have law enforcement take my fingerprints and go through all this stuff to send into the gun line? That's what to send into FBI NICS. That's what FBI NICS calls an appeal. And here's what I tell people. If you have a cylindrical object that holds liquid and you call it a plate, you can call it whatever you want. I call it a glass, a cup, or a vessel. But you have now spent all this time and all this money and taken your fingerprints, goodness knows how they're going to be used, and sending them into FBI NICS. Rarely will you get an answer other than for weeks and weeks and weeks. You say, well, meanwhile, what's this poor person to do? And the answer is wait. Usually the first letter you get from them, and this is quite helpful. I could show you dates and letters like this. You are suspected of being the person who has a conviction under 18 USC blah, blah, blah that bars you from a gun. And you say, okay, that's helpful. How can I deal with this? And so you write them back. You don't fax them. You don't email them. You don't call a person. You don't walk in the door. And you go through, you get the same letter again and again and again. They don't tell you that we think that you were convicted in Concord District Court on June 4th, 1944 in docket number ABC 123. You simply, it's a circular system, like the spinning wheel that you get on Windows when the thing is going nowhere. So to say it's a very efficient system, it's not an efficient system. It might be an efficient system for them, but it's not an efficient system for the citizens of the state. And unfortunately, the other thing I want to point out is when people say that you call the gun line and you don't get an answer, they have an answering machine. All you have to do is leave your message. Leave your name, address, and phone number. They return your phone call. Now, I understand somebody sometimes wants to speak to a person, but the reality is that all of us in situations have to leave messages on voicemail sometimes. So the bottom line is that the gun line is taking, they have told you, between 2 to 3 minutes up to 15 minutes for a check. If you talk to many dealers, you're going to find that's normal. That's what sometimes FBI NICS takes. But the largest issue is the citizens of this state need someone that's responsive and responsible to them, which means if they're denied their constitutional Second Amendment right, they need a person who's going to answer to that, an office, a human being, an address. And they have that. And they need it for low cost, and they need it promptly. One of the things that you're going to have is if you go to FBI NICS, you're not going to have answers for weeks and weeks and months. And I don't want to be the one to look the first family of a woman who was trying to protect herself from a stalker who couldn't get a gun because FBI NICS wouldn't tell her why, and there's a snafu. I don't want to look at her family with her dead body and say, I don't know what to tell you. I tried to get the answer from FBI NICS when the gun line would have literally given her an answer within minutes or hours. And so I respectfully say to you, ITL this bill. I'm happy to answer mechanical questions. I too am one of these people who have done these things from soup to nuts. I've physically been at the gun line more than once, sat through their process and procedure. A lot of people don't even know where it is, let alone have been back there. And I can tell you that I believe this new system they're using is absolutely as good as it's going to get. I'm sure they're going to tweak it. But the bottom line is the citizens of this state have a right to responsive government here. And we could save hundreds of thousands, if not millions of dollars, and get rid of jury trials. Save us a lot of money. But how much is due process worth? And I think when you talk about the fact that they say, well, we have 7 employees. Yeah, but those 7 employees, if you listen to his testimony, they also do the gun line, or I'm sorry, they also do all sorts of other checks as well. And so again, I'm happy to answer any questions that you may have.
Senator Gannon has a question.
Thank you, Madam Chair. If, as you say, NICS is so unresponsive in problems, why don't I hear that from the advocates of this bill? Because they all have rifles and shotguns. Wouldn't they be getting denied quite often and then say that that's a bad system? Why am I not hearing that?
I'll tell you why. Because the 25% of people in this country that have records are embarrassed. I can't get any one of those clients to call you and say publicly, hi, I'm Mrs. Smith. I work at the local Shop and Save or whatever, and I have a conviction for ABC. It doesn't bar me from guns, but it sometimes holds up me getting a gun. If you had a conviction for ABC, but it didn't bar you, would you want to call in here and give your name and address and phone number? So I'll tell you that's why they are what I say is the silent majority, because if you look at the fact that 25% of Americans have criminal records, like I said, I can't get one client willing to call up and tell you what's happened because they don't want their employer to know they have the record. They sometimes don't want their spouse to know they have a record.
Thank you.
Okay, are there any further questions? Okay, seeing none, thank you very much for your testimony. We're going to go to the final speaker, Senator Clegg. Senator?
Thank you, Madam Chair. Members. Good afternoon.
We've heard a lot of testimony this afternoon, and I'm going to ask you not to repeat testimony that we've already heard. So if you could offer us new information, that would be terrific.
Madam Chair, I'm hurt that you would think that I would keep you when I didn't need to.
Okay, we're not going to go down that road, Senator. So
Madam Chair, members of the committee, I'm not a lawyer, but I've appeared in court many times. And I'm not an FFL, but I've bought and sold guns many times. I've been in competitions, but never shot myself. And I can say that I've trained quite a few people myself. As a member of the legislature and part of the body you're in, I spent a lot of time on the gun line. And I'm going to tell you that every time we get to this point, we always have a so-called resolution. That resolution lasts for a short period of time until you can't file another bill. And then we go back to the back burner. They don't want the business. They don't service the business. And it's time to just move on. This has to be at least the 9th or 10th time I've seen us try to make a resolution work. Now, I should have said in the beginning that I'm here representing Pro-Gun New Hampshire. Pro-Gun New Hampshire is a nonpartisan group of gun owners. And we've worked very well with the legislature over the years. I will tell you that we find that some of the information given to you today is incorrect. First off, the domestic violence orders, the site you were given from a recent attorney is for federal and not state. And the federal guideline, and NICS does take all of the state domestic violence filings. I will tell you also that you cannot walk in. First off, I'll tell you that you don't always get a number when you get a denial. And I will tell you that the website for the gun line says, do not come to the counter. Don't do it. Some of the information you got is 10 years old. And the gun line can't help you on guns and on long rifles or shotguns. And it says so on their site. It's time that we moved forward, not backwards. Yes, they fixed it for a short period of time. And I understand that for some groups, resolution is bad for their financial bottom line. It's always easier to say, kill the solution. It's not good enough, so that I can go out and ask everybody I see for $25 so I can fix the problem. Please don't allow them to do that anymore. We fight and we fight on this on a constant basis, and we shouldn't be doing it. We know that the federal line does everything it's supposed to do. We know that the gun line says don't come to the counter. And as far as people getting delayed because of their military service, I have some very good friends who have served this country with great honor and distinction. And not one of them, not one, has ever been denied by NICS. And I'm proud to say that a lot of them are special forces. So I don't know where all of this misinformation comes from. And I think I do know why, because when you resolve a problem, you can no longer profit from it. So I'm asking you to vote yes, move it forward, and let's stop saying that the NICS line, the gun line in New Hampshire can be fixed. They can't. And I'll leave you with one memory that I've always had, and it's really bothered me, is the time a gentleman, well known by the court system in law enforcement, who had some serious mental illness, applied for a gun. And he showed no signs of mental illness when he went to buy it. After 13 days, he went back to the gun store and said, "Have I been denied?" And they said, "Geez, no, you haven't." So they gave him a gun. That gun was then used to shoot a police officer in Manchester. So don't tell me that the system works. It doesn't. In fact, it hasn't worked to the point where it actually harmed one of them. NICS would have responded. NICS would have responded a lot faster than 13 days. And I understand there's a proposal out there. Let's wait 88 days. Really? Let's not go down that road. We have a system in the federal government that works, and I don't care who the president is. The system works. I'm going to rely on it, and I think it's time that we moved on and we passed this bill. Thank you very much.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, I'm going to go ahead and close.
Senator
Margaret?
Carson?
Yes.
We do have 3 others with their hand raised.
Okay, let's put them through. Mr. Blackden?
Hi, can you hear me?
Yes, I can. I'll tell you what I've told everyone else, Mr. Blackden. We've had a lot of testimony on this bill. We are way over time here.
Yep.
And we are only interested in hearing new information, so please do not repeat information we've already received.
Okay. I am an FFL, and from hearing the testimony today, I am probably the luckiest FFL in the whole world, because I have never waited 9, 10, 12 months for any delay at all. Military members do get delayed, and then they are finally passed through. I am not in favor of getting rid of the state police gun line due to the fact that in the political climate we're in, by the stroke of a pen, if the NICS system is gone and the New Hampshire system is gone, who are we going to call to buy a handgun in the state of New Hampshire? The answer is nobody. So you have to think about that. The state police has done an excellent job, in my opinion. They have been putting me on hold every time I call in, and within minutes get a response. I have not been mishandled, and they have been doing a very good job. And that's speaking over years and years of time. And I don't know where all these supposed problems are or why people are having them, but I have never experienced them at all. And I think it would be a disservice to the people of New Hampshire to get rid of the gun line, because I think they are doing a good job and they have improved lately over what I have seen in the past, which was not bad. After 15-minute callback, they put you on hold now and do the check while you wait. So I would say ITL this, please.
Okay, thank you for your testimony. Is there any questions from the committee? Seeing none, thank you. Margaret, let's move on to the next person. Representative Mr. Hall?
Thank you, Madam Chair. Can you hear me?
Yes, we can. I'm going to tell you the same thing I've told others.
Thank you.
We are way over time. We've had a lot of testimony here. Please do not repeat testimony we've already heard.
Yes, thank you. Representative Hull, or former Representative Hull, Town of Dunbarton, speaking on behalf of myself as well as the New Hampshire Firearms Coalition. One of the things that has not been brought up, and I've listened to the testimony from the beginning, is the gun line was not performing well. I think we're all in agreement with that. There has been numerous issues along the way. Dealers were frustrated, potential purchasers are frustrated, and that rose to a boil. And when Senator Gaida filed this bill, it brought up the issues to a head. And in one sense, it's driving to closure the fact that the gun line needs to be performant. It needs to actually respond in real time. NHFC has consistently said it needs to be fixed or it needs to go away. It's gotten better, but I don't know that I would call it fixed yet. And what is fixed? Fixed is that we have an instant response. Okay, instant meaning when you call into the gun line, you're not on hold for 20 minutes before you can talk to an operator. There's an operator who picks up, you talk to them, you give them the information necessary, and from there, it's processed in a 2 or 3 minute time frame. We've seen numerous issues in the December time frame. As I've said, it's gotten better. I've put phone calls into the gun line's office, talked to the major and one of his bosses. I think we can do better. The fax line clearly needs improvement if we're going to keep it in the state. That's my testimony.
Okay, thank you very much for your testimony, Mr. Hall. Are there any questions? Okay, seeing none, thank you. Now we're going to hear from the final speaker.
Yes, and they are calling in on the phone.
Okay. Hello?
Good afternoon. Good afternoon, Madam Chairman.
Could you please identify yourself for the record?
This is Jay Simpkin. I'm a federal firearms licensee domiciled in Nashua, New Hampshire. I want to rebut. You did, but Senator Clegg made a statement that misrepresented what I said, and it is a material misrepresentation. I did not at any point state that members of the military who have served in special ops units or other folks who've held high-level security clearances have been denied by FBI NICS. What I said was that such persons will be delayed by FBI NICS if there is no one in the FBI NICS Center with a security clearance adequate to review their records. There's a big difference between delay and deny, as I'm sure we will all agree. It is that sort of imprecision which is misleading that riddles the testimony of those who support this bill. This is a technical realm, and it is important that folks be technically accurate.
Okay, thank you very much for your clarification. Are there any questions from the committee? Okay, seeing none.
Thank you, Madam
very
Chairman.
much.
I appreciate it.
Margaret, let's go ahead and we're going to close the public hearing on Senate Bill 141. I'm going to put the committee in recess for 15 minutes until 3:30. Thank you very much.
Hey, Bob.
Rick?
Members, hang on a second. Yes.
Yes, hi, Rick. We're on, we're live now, so is there a question?
I know we're live.
Okay.
Nope.
Okay, I didn't know if you had a question.
Jenny, I can't give you COVID over the computer.
Looks like everybody got a snack. We had been watching Senator French eat cookies, and I think everybody was hungry.
Cookies?
Yeah, you didn't see Senator French munching on look like chocolate chip cookies.
It was just Chip Ahoy's.
Well, it's Chips Ahoy, Senator.
Yeah.
Oh, wow, there you go. Okay. Is it, let's see, it's 3:31. So I am going to go ahead and take the committee out of recess. Next, I'm going to open the public hearing on Senate Bill 134. And I am the prime sponsor of this bill. This is an omnibus bill. So I'm going to do what I've done in the past. I'm going to read through each part of the bill, naming the LSR and the prime sponsor of the bill. And then we will go back and we will call the prime sponsors of each section, get their testimony, and then open the testimony up to the public. Part 1 of this omnibus bill is LSR 21-0931, relative to prohibiting certain uses of laser pointing devices, sponsored by Senator Carson. Part 2 is LSR 21-0498, relative to the revised Uniform Law on Notarial Acts and the Uniform Real Property Electronic Recording Act, sponsored by Senator Kavanaugh. Part 3 is LSR 21-0913, relative to incarceration under a suspended sentence, sponsored by Senator Whitley. Part 4 is LSR 21-0932, relative to civil liability for damage to highways, sponsored by Senator Carson. LSR 21-0934, relative to structured settlement protection, sponsored by Senator Carson. LSR 21-0944, establishing the New Hampshire Collaborative Law Act, sponsored by Senator Carson. LSR 21-0979, relative to probate administration, distribution upon intestacy, and powers of attorney, and adopting the Uniform Disclaimer of Property Interest Acts, sponsored by Senator Whitley. Part 8 is LSR 21-0141, relative to school employee and school volunteer criminal history background checks, and establishing a committee to study Department of Education oversight of criminal history background checks for private schools, sponsored by Senator Khan. Part 9 is LSR 21-0996, making an appropriation funding mental health intervention training programs, sponsored by Senator Gaida. Part 10, LSR 21-0192, relative to interface with the enjoyment of a dwelling place, sponsored by Senator Ward. Part 11, LSR 21-1013, relative to employer access to motor vehicle records, sponsored by Senator Carson. And LSR 21-0969, relative to the authorization to grow industrial hemp, sponsored by Senator Carson. So we're going to go ahead and we're going to open the public hearing. We've already done that, excuse me. We're going to start with Part 1, LSR 21-0931, relative to prohibiting certain uses of laser pointing devices. I was asked to file this bill, and we're going to have testimony, extensive testimony as to why we should have this. As we all know, the use of laser pointing devices can be very dangerous in certain situations. And I believe that this legislation will help clarify that particular issue. Secondly, let's go on to LSR 21-0498 and recognize the prime sponsor, Senator Kavanaugh.
Hello, Chairman Carson and committee members. Thank you very much, and thank you for all of your dedication and patience today. It's been a long day. I don't know what everyone else might know. It started at 9 a.m. for us on Commerce with Senator Gannon and French. So I appreciate it and appreciate the thing you're doing. So I'll jump right into it. Hello, my name is Kevin Kavanaugh, representing Senate District 16, the towns of Bow, Candia, Dunbarton, Hooksett, and Manchester wards 1, 2, and 12. And I'm here today to introduce Section 2 of Senate Bill 134, relative to the revised Uniform Law to Notarial Acts and the Uniform Real Property Electronic Recording Act. Just to give you some background, I did introduce this last year to establish a commission to study the implementation of remote online notarization for New Hampshire. And so far, we've seen about 28 states modify their notary laws to allow for this practice, and felt it was time for New Hampshire to explore joining them. While this did pass the Senate unanimously because of COVID and so many other bills, the bill was failed to be scheduled for a hearing in the House. So here we are again. This came at a time when remote notarization would have been most helpful, as numerous businesses moved to remote means. Governor Sununu issued Executive Order 11 to allow a form of remote notarization, which has been helpful to businesses and residents during these challenging times. Governor Sununu also indicated that some of the priorities of this session should be addressing executive orders that could be put into statute. As a result, a group of stakeholders that originally would have met in the study commission originally proposed last year met over the summer and fall to draft the more robust remote online notarization law in line with the other states, but what other states have done, and with the input from New Hampshire-based stakeholders. That language was introduced here in this part of Senate Bill 134 FM. Stakeholders who participated in the drafting of this language are the Mortgage Bankers and Brokers Association of New Hampshire, New Hampshire Bankers Association, New Hampshire Credit Union League, New Hampshire Realtors, Registers of Deed, title companies, and the Secretary of State also provided input and is satisfied with this language. Members of the stakeholder group who worked in drafting this legislation are available today to answer any technical questions you may have on this bill, as well as remote online notarization. In general, I would defer any questions to them, given their expertise in this knowledge and the knowledge in this area. So thank you very much to the committee members and for taking my testimony. And I urge you to support Section 2 of 134. And again, thank you all very much for your dedication and patience again. So thank you, everyone.
Thank you, Senator, for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none. Next, we're going to move on to Part 3 and recognize the prime sponsor, Senator Whitley.
Thank you, Madam Chair. For the record, my name is Becky Whitley. I'm honored to serve New Hampshire Senate District 15, which includes the wonderful communities of Concord, Pennacook, Henniker, Hopkinton, and Warner. So this bill is a policy that passed the House last year, but was just stalled due to COVID. This bill would simply allow, this portion of the bill would simply allow people to apply for a suspended sentence earlier. So if granted, they would have time to return to prepare to return for their communities before they would reach 2/3 of their minimum sentence. This bill is not about early release. It's just about the timing for applying for a suspended sentence. Thank you, and I'm happy to take any questions.
Okay, terrific. Thank you very much for your testimony. Are there any questions from the committee at all? Seeing none, we're good to go. The next section, which is LSR 210932, relative to the civil liability for damage to highways, was sponsored by myself, Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And this was filed at the request of the Department of Safety, and this is to help them collect monies that is owed to the state when people have caused damage to our state highways. Are there any questions? There are folks here from the Department of Safety to answer questions if you should have any. Okay, seeing none, we're going to move on to the next LSR, which is LSR 210934, relative to the structured settlement protection. And again, this was sponsored by myself. This is, excuse me, I'm Senator Carson. I represent Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration today LSR 0934. I was asked to file this because we are the only state that have not updated our structured settlement laws. And we would like to come into line with all the other states. The folks that have asked me to file this, they have been working diligently with a number of different entities, and they do have an amendment to come forward, and they are ready to speak on this. And so I would ask you to hold your questions until they are recognized to speak. Okay, I'm going to move on to LSR 210944, establishing the New Hampshire Collaborative Law Act. Again, Senator Carson, Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. This was a bill that was filed last year. Unfortunately, I believe it was part of the one of the big omnibus bills that was vetoed by the governor. So I was asked to bring this forward. We have folks that are here that are going to be able to speak to what this particular law would do. And so I would just ask you to hold your questions until they're identified. Next, we have LSR 210979, relative to probate administration, and this was filed by Senator Whitley.
Thank you, Madam Chair, again, and good afternoon, members of the committee. So for the record, my name is Becky Whitley, and I'm honored to serve Senate District 15, which includes Concord, Pennacook, Henniker, Hopkinton, and Warner. Part 7 of this bill expands the waiver administration process in probate proceedings. It makes a non-substantive clarification to the intestacy statute and makes some clarifying changes to the New Hampshire Uniform Power of Attorney Act. And it also adopts the Uniform Disclaimer of Property Interest Act with the addition of some language that was requested by DHHS. Both of these bills were also brought last session and just got lost in the COVID shuffle. So I will note that the creation of this bill was done in collaboration with a legislative working group of trust and estates attorneys, about 45 trusts and estates lawyers in New Hampshire. And I will definitely defer all technical questions to those folks, but in particular, Attorney Ben Hillman from Shaheen and Gordon, who can describe all the work and the reasoning that went into developing this part of the bill. Thank you very much.
Thank you very much for your testimony. Are there questions? Okay, seeing none, we're going to go on to Part 8, which is LSR 1041, and recognize the prime sponsor, Senator Khan.
Thank you, Madam Chair. I have worked with the Department of Education, and Diana Fenton, I believe, is on this phone call, as well as with the Department of Safety. And the two departments collaborate on doing criminal history background checks for licensed educating and educators in the state. The nature of this is that it's a follow-up to legislation that became law this last legislative session relative to the role of the Department of Education to do criminal history background checks on all licensees and relicensees. As well as for school bus drivers and attendants. Those statutes in 189.13a became law or effective in January of 2021. And these amendments to 189.13a work to further explain what the role of the school district is and what the role of the Department of Education is in both storing information regarding criminal history background checks on school personnel and retaining that information and conducting those background checks. So you'll see some clarifying language about turning over any information that identifies that a person has been convicted or has pending charges relative to the 189.13a Part 5. And those crimes include the kind of crimes you'd want the State Board of Education to hold on to if you were trying to license those personnel. There are felony charges, first degree murder, manslaughter, but also sexual assault and pornography charges that were either pending or brought against a person. So that's a good thing. These don't need to be retained by the school district beyond 60 days. And it's a good thing that they pass that information on to the State Department of Education in the event that anybody is checking the credentials of a person for hire. As you get further into the bill, it describes the roles of the school district relative to volunteers in the schools and who is receiving and storing that information. The bill then adds Section 4, which begins to define the role of the Department of Education relative to doing criminal history background checks on credential applicants and candidates, which means a student at a higher education institution in the state of New Hampshire. Currently, the FBI will not conduct a criminal history background check for a state college. It'll do it for the Department of Education. For K through 12 school districts who serve minors. They do not do that for the colleges. Colleges need to rely on the state background check. And in this instance, we need to go farther. We need to maintain the same standards for anybody who's going into the school to have contact with kids as we would for somebody who is a first-time hire. So that is the intent of this legislation, to grant to the department the same kind of authority as they have over other licensees. And this is for pre-candidates. For candidates, these are valid for the duration when a student might be continuing to pursue their degree at college over a 3-year period. And This doesn't prohibit a school district from doing this background check, but it does say that the school will do that and work through the Department of Education to do those initial background checks. And then finally, in reviewing the statute, we recognize that while this applies to public charter schools and public schools, these kind of background checks do not apply to non-public or private schools that serve students under 18. And it's a question of what the authority ought to be for the state to do this kind of criminal history background check for private schools. It's why to name a commission, a legislative committee that's viewed to work in a fairly short order to review our current statutes and see how they might be applied and used for background checks of employees at private schools. There's no predicted outcome there. It's just to recognize that we've had cases that have been high visibility in the state of New Hampshire that give us a clue that this is an area for some conversation to see if there's some statutory language that ought to be brought forward in the future. So those are the various parts of the bill. And again, Attorney Diana Fenton of the Department of Education is present to go through this if there are further questions.
Thank you very much for your testimony, Senator. Are there any questions? Okay, seeing none, we're going to move on to LSR 21. This is part 9, and recognizing the prime sponsor, Senator Gaida.
There we go. Madam Chair, members of the committee, this is a small amount of money with a huge impact. This bill asks for $210,000 to continue a federal grant that runs out in September. This grant allows NAMI to instruct our police academy in mental health issues and how to deal with people they interact with that are having mental health issues. As you well know, the incidence of mental health problems has escalated because of COVID and escalated in general. And more than a few of the police shootings that have occurred, one up in my area of the woods specifically, involved a person that had mental health issues. And I think had the officers had training, the outcome might have been different. This $210,000 number comes from the fact that it's a $120,000 grant that expires in September. And so we would use $120,000 for fiscal year 22 and $90,000 for the remainder of fiscal year 21. That would fully fund this program for the ensuing 2 years. The governor's interested in this. He may put it in his budget, but we really need to get this in there because of its importance to our citizens and to training our police to properly interact with those with mental health issues. Thank you, Madam Chair.
Thank you very much, Senator. Are there any questions for Senator Gaida? Okay, seeing none, thank you. Next, we're going to go to part 10, which is LSR 0192, and recognize the prime sponsor, Senator Ward. Good afternoon, Senator.
Good afternoon. Glad we finally got to this point.
Me too.
So part 10 has to do with the enjoyment of a dwelling place. This was a bill that was introduced last session, but it didn't make it through the whole process. One of my constituents had contacted the police department in his town because he was being bothered by drones coming over his curtilage and hovering very close to his bedroom window. And this happened on several occasions. He went to the police department and they told him there was just nothing they could do about it. So we talked about it and we decided to put this in. This gives the opportunities to do something if you find that you're bothered by drones coming, too close to you and particularly over your property. recognizing that I guess it's the Federal Aviation Act that has something about drones, but nobody should put a drone across over somebody else's property. And certainly they should not hover over the bedroom windows. And it got so bad for this gentleman that his wife refused to get undressed in the bedroom. She moved to another room, and that's not a good thing. So anyhow, this bill gives a way for him to complain, and they can bring it to Superior Court, and they can actually receive some money back in case they have to hire a lawyer. So this is essentially the essence of this particular bill.
Okay, thank you very much, Senator. Are there any questions for Senator Ward? Okay, seeing none. Next, we're going to move on to section 11, which is LSR 1013, and I am the prime sponsor of this section. For the record, my name is Sharon Carson. I represent the Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon, LSR 1013, relative to employer access to motor vehicle records. This section would streamline the process for employers to obtain motor vehicle and license records from the Department of Motor Vehicles to allow the release of electronic records, which will ultimately help protect public safety. Virtually all other states allow electronic employer driving record and license status checks. This bill would put New Hampshire in line with what is currently practiced across the country. Importantly, these records are already disclosed to employers on an individual basis under New Hampshire law. This bill would merely change the manner in which the records can be released to allow them in electronic form. Thank you. Are there any questions? Okay, seeing none. And we're going to move on to the last LSR, which is part 11, part 11, part 12. LSR 0969, relative to the authorization to grow industrial hemp, which is another bill that I sponsored. For the record, Sharon Carson, representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And this bill is a refile from last year. New Hampshire for many years struggled with whether or not we would allow our citizens to grow hemp. It is something that is still prohibited under federal law, but a few years ago, the federal government added provisions that would allow people to grow hemp under certain circumstances, usually in collaboration with a university or university system. We studied the bill, thought this was a great idea, gave people the ability to do this. But there seems to be some issues that need to be worked out, and this bill seeks to do that. We have had inquiries from folks who would like to start to be able to grow industrial hemp and to use it. So hopefully we can do this. Unfortunately, it was part of an omnibus bill that died last year. So I'm just going to end my testimony here. And if you have any questions, be more than happy to answer them. Seeing none. Okay. Now we're going to move on to hearing from the public. What I'm going to do is what we've done in the past, where we're going to start calling people. When we call on them, we're going to ask them which section of the bill they're speaking to. So that way it's going to be easier for Jenny, who's taking all the hearing notes for today. So we're going to start with Rebecca McBeath.
Rebecca, I did not see your name on the list. If you could virtually raise your hand, or if you were calling in by phone, press *9. Senator, I do not see Rebecca.
Okay. All right, next we're going to go to David Cuzzy.
Senator, I believe Mr. Cuzzy did contact us and ask if he could have 2 other individuals testify with him at the same time.
Yes, Aaron Poitras and Tim Bishop. So if I don't know if you can put them all through at the same time. Okay, let's give it a whirl.
Thank you, Madam Chair, and members of the committee. For the record, my name is David Cuzzy with Prospect Hill Strategies in Concord. Honored to be the longtime Concord representative for BA Systems, and as the chair just noted, joined today from BA Systems by Ms. Erin Poitras, who is the company's laser safety officer based in Nashua, as well as Tom Bishop, who is a government relations director for the company, also based in Nashua. And we are testifying in support of Part 1 of Senate Bill 134. Part 1 is the bill portion of the bill relative to prohibitions regarding laser pointers. And Madam Chair, with your permission, my thought was we could have Ms. Poitras testify briefly and give the committee an overview of the hows and the whys. And we ended up talking on this topic here this afternoon. And then when she's done with her brief comments, between myself and Ms. Poitras and Mr. Bishop, we'd be happy to answer any questions that that you and the members of the committee may have. And so I think with that, Madam Chair, again, thank you for your support or your introduction of this bill. And if it's okay with you, ma'am, I'd like to turn it over to Ms. Poitras.
That's fine with me.
All right. Can everybody hear me all right?
Yes, we can.
Wonderful. All right. Good afternoon, Chairwoman Carson, members of the committee. For the record, my name is Erin Poitras. I'm the Laser Safety Officer for BAE Systems, Electronic Systems Sector, based out of Nashua, New Hampshire, and I'm testifying on behalf of the company. BAE Systems supports Part 1 of Senate Bill 134 regarding the prohibition of certain uses of laser pointing devices. We don't have any position on any of the other parts of this omnibus legislation. By way of background for everybody, in 2016, a bill was signed into law prohibiting the shining of laser pointers at airplanes, law enforcement officers, law enforcement vehicles, persons, occupied vehicles, or other structures. This bill was in response to these types of laser pointer issues that we've seen in New Hampshire and across the nation at this point. So the 2016 law included very limited exceptions, however, which had the unintentional effect of making even some of our everyday uses of lasers illegal. So our vehicle sensors, golf range finders, hunting range finders. As Senator Carson knows, our company became aware of an issue with this New Hampshire state law about a year ago. At the time, it was too late to seek any legislative remedy when it was brought to our attention. The reason that we approached Senator Carson with the issue is that the law also prohibits some research and development activities that aerospace and defense technology companies like ourselves, BAE Systems, conduct with lasers and laser systems. So today, BAE Systems is taking every precaution to legally work around the unintended prohibitions that were set forth in the 2016 law until the legislature can provide a remedy. In addition, we're not aware of any law enforcement entity interpreting or enforcing the statute beyond the intent of the current law. However, we do believe that appropriate exemptions should be placed into the statute to clarify those lawful uses of lasers, while also ensuring that malicious use of lasers and laser pointers remains prohibited under that law. I'd like to thank the Department of Safety, Transportation, and Fish and Game for their willingness to provide us some feedback while we work to provide a solution for Senator Carson to introduce to the Senate. I respectfully request that the committee recommends ought to pass on Part 1 of Senate Bill 134. I want to thank you for your time and your consideration, and I'm happy to take any questions that you might have for us at this time.
Okay, thank you very much for your testimony. Mr. Bishop, do you have anything you'd like to add?
No, ma'am, I'll defer to Erin, but we're happy to answer any questions you might have.
Okay, thank you. Are there any questions from the committee? Okay, Senator Khan.
Thank you, Madam Chair. What kind of research are you folks currently doing? I'm just you guys are cutting edge, a great example for our New Hampshire technology sector. Just a couple examples, I think you'd enlighten us.
So broad strokes, a lot of our
without
laser
violating
technology-
Department of Defense security.
Yeah. Broad strokes are a lot of our laser research, or actually all of our laser research, is really around using lasers for communications and communications disruption. So we are not in the business of weaponizing laser energy. We are in the business of researching laser use for communications and communications disruption. So we may be transmitting laser energy from one airplane to another, from a vehicle to a moving target, things of that nature.
Okay, autonomous vehicles is one of the possibilities.
Mm-hmm.
Thank you.
Okay, are there any further questions? Okay, seeing none. Thank you, Mr. Cuzzi, Ms. Poitras, and Mr. Bishop. We appreciate your testimony this afternoon. Okay, next we're going to call John Diana.
Thank you, Madam Chair. Can you hear me?
Yes, we can, Mr. Diana. Could you, when you introduce yourself, can you please identify which section of the bill you're speaking to?
I sure can. My name is John Diana. I'm the General Counsel and Chief Compliance Officer for Samba Safety, and I'm testifying in support of Part 11 regarding employer access to motor vehicle records. My company has a singular mission, and that is to assist companies to improve driver safety. Our services reach over 100,000 employers in the United States and Canada. And our services include helping employers interpret and understand motor vehicle records. For clarity, I just wanted to, there are really two key elements of a motor vehicle record. One is it tells you the status of someone's license. Do they currently have a valid license as of the day of the record? And secondly, it provides a recent history of violations. Serious violations could include DUIs, reckless driving, felony with a motor vehicle, and it would include things like speeding, etc. Motor vehicle records are critical for public safety. They are really the best public record to assess qualifications of a driver. And I'll share some stats with you. 3 to 5% of accidents today involve drivers without a valid license. 19% of fatalities involve a person without a valid driver's license. 26% of fatalities involve speeding, and alcohol is a contributing factor in 39% of accidents. So all of these are really critical statistics for employers and for public safety. I'm testifying in support of this bill because today the New Hampshire DMV interprets state law to require that records be obtained on an individual basis with a notarized release. So for employers, that would not include electronic access. New Hampshire is the only state that restricts access in this manner. It's impractical, it's costly and time consuming for employers. And it makes substantially more likely that an employer will put a driver behind the wheel without checking a motor vehicle record. And my company has been collaborating with the New Hampshire DMV for over a year, and the DMV encouraged us that really the only way to address these concerns would be through legislation. So Section 11 permits electronic access for employers and their agents. It'll benefit employers, contribute to improved road safety, and ultimately help reduce accidents in New Hampshire. And most importantly, it will also maintain federal and state protections for individuals. I can give you the most important example. Federal and state law require, if you're going to pull a motor vehicle record on an individual, that individual will receive a disclosure that you will pull the record, and that individual consent in writing to the release of the record. So thank you very much for being able to speak to you today.
Thank you very much for your testimony, this afternoon, Mr. Diana. Are there any questions from the committee? Seeing none? Oh,
Yeah.
excuse me, Senator Khan.
Just a comment, Madam Chair. If folks can also point to the page, it's an awfully long bill, and the section numbers, I think you just referred to section 11, which was the effective date. There are a lot of sections, subsections, and that's all. Thank you.
Okay, thank you. We can certainly ask. Okay, thank you very much, Mr. Diana. Next, we're going to go to Marie Mullen. Good afternoon, Ms. Mullen. If you can reference the section of the bill you are speaking to and the page number, we would greatly appreciate it.
Okay, I'm going to be speaking to 3 sections of the bill. So unfortunately, I didn't get a chance to get all the page numbers. But the first one is section part 1. So that would be on the first page anyway.
Okay.
So in relation to part 1, DOT, again, first of all, my name is Marie Mullen. I'm the Director of Finance for the Department of Transportation. And so for part 1 of this bill, DOT does support this bill regarding the laser pointers. There's just a couple of comments that we had, maybe for technical items to consider. The first one is RSA 422, sections 28 and 29, which is the New Hampshire Aeronautics Act prohibitions. We believe that there should be some reference to this RSA to exempt that or point back to this, RSA 631 for this change so that they reference each other. So that's just one area we thought legislative services could cross-check this and make sure that it's covered in both RSA 422 and 631. And then the other comment we had was related to the definition of an authorized person. It defines person, but we're just wondering if authorized person should be defined in here so that there isn't any confusion with that regard.
Okay.
So that's it for section 1. The next area is part 4 of the bill. I will try and find the page here.
Page 5.
I have part 10 of the page 10 of 38. So
you're page 10.
Yeah, it's the way my printer does this.
Oh.
I was looking at section 5, not part.
That you're going to speak to relative to civil liability for damage to highways, correct?
Yes,
Okay.
That's correct. So in this section, this bill was at the request of the Department of Transportation. Each year we bill hundreds of thousands of dollars related to damage to the highways on both the turnpike and the state highway system. In fiscal years 19 and 20, we billed over $2 million in damage to folks who, whether through insurance or directly for damage that they had caused to the highways. Related to this strict liability RSA, it has been interpreted that the department must use actual costs in billing claimants for these items. It has been the practice of the department to use reasonable estimates. And this is an accepted practice with insurance companies and is needed by the department due to the nature and timing of the damage to state property. For an example, damage that occurs in the winter cannot be fixed right away, so it can take several months. a longer period of time before the snow melts, that the frozen conditions are not there, that, so that we may make the repairs and have actual costs. So that can take several months for us to be able to bill, and many insurance companies and citizens don't want to wait that long to get invoiced for actual costs. So we've worked with the Attorney General's office to come up with the change in language here and to define the costs as being either actual costs or reasonable estimates. And we're looking to have that language changed to allow us to be able to invoice the claims more timely and be able to collect from folks who've done damage to the system. We do have a request on the section 3, which is the effective date. In speaking with the Attorney General's office, we'd like to have the section apply retrospectively and prospectively to all persons. That way, because for the past year and a half, we haven't been able to bill we haven't been able to invoice several folks because we didn't have actuals, we were using estimates. And so we'd like to be able, for the past year and a half, to be able to go back to the folks who haven't paid and be able to collect for the damage on the system. So we'd like to apply it retrospectively and prospectively.
Okay, are there, okay. And you want to move on to the last section that you identified you'd like to speak to?
Sure, if there's no questions. So the last section is part 10, is section 10, related to the dwelling.
That's on page 46.
Thank you. So I've heard from our Bureau of Aeronautics here at the department, and there is a concern if the intent of this RSA is to target the use of airspace. The use of airspace is federally preempted, and states and local municipalities cannot regulate airspace. So we wanted to make you aware of the federal preemption related to regulating airspace. So we just wanted to make sure that in the bill, if the intent is for airspace, for that to be reviewed.
Okay, thank you very much for your testimony. Are there any questions from the committee? Senator Gannon.
Going back to part 4, just remind me, it's been like 72 years since I was in law school. Why are you using strict liability? Back on the damage to highways, I'm sorry.
I believe this was passed, I don't know if it was before my time, I'm not sure, but this was the law that was put into place to use strict liability. So once it was put into place, that's why I think the language had it become more restrictive. So we've had some trouble being able to invoice and bill people for claims. So we're trying to have it be a little more eligible to be able to use estimates, reasonable estimates.
Okay, so if I blame you for putting the stop sign, can I follow up, Madam Chair? I just
Oh,
remember
yes, of course.
4 or 5 or 6 years ago. I think I was around.
I do know that a member of the Attorney General's office is here to testify on behalf of this as well, who assisted with the language. So they may have a better legal interpretation than I would of the bill.
My only thought was like, say, I think it's your fault because you put the sign too close to the road or something and I hit it. Am I going to have to overcome this huge hurdle to prove it was your fault? Anyways, not a huge thing to me. We can move on. Thank you.
Thank you.
Okay, are there any further questions for Ms. Mullen? Senator Khan.
Thank you, Madam Chair. Just relative to part 10, I assume you're expecting some type of notwithstanding federal, and you could provide us that federal reference.
Yes, I'll speak with our Aeronautics Bureau to get what language they would recommend. I know that Tricia Lambert's listening on the call, and we'll get you that language to help with that.
Okay, are there any further questions? Okay, seeing none. Thank you very much, Ms. Mullins. Next, we're going to go to Zachary Toll. Good afternoon, Mr. Toll. If you could please reference the section or sections of the bill you're going to be speaking to, and if possibly a page number, that would be terrific.
Of course. Yes, I'll be testifying as to Part 4. That is on page 14. And for the record, I'm Attorney Zachary Toll for the New Hampshire Office of the Attorney General. I am the attorney for the Debt Recovery Unit, and I'm testifying in support of this bill, specifically Part 4. So Part 4, Director Mullen kind of gave a good overview as to what exactly this bill is for. I'm the attorney who actually gets to enforce the bill and do it on a day-to-day basis. What we're looking at today in Part 4 is that there are 3 key components that are actually being changed. The first, as Senator Gannon actually noted, was the change from merely saying shall be liable to saying shall be strictly liable. Currently, the courts do interpret the shall be liable as a strict liability standard. The intent of changing the language there is to make it more clear for anyone who's looking at the bill that saves time both in the court. We've had to argue a couple times now. Each time the court has been very consistent. Shall be liable is strict liability. And also as anyone who is looking into this, a little bit more clarity into what exactly the standard will be. The second remedial measure is just that there's a slight change to some of the language going from just saying damage to highways to including the protective barriers within any structure or device that is part of the highway. Once again, this is more remedial, more so than adding anything. Typically when the court views this, they take a very wide definition of what the highway actually encompasses, both the road surface itself, but also signs, potential barriers that have been put up for construction. It could mean a lot of different things, anything that aids in the functioning of the highway for its purpose. By just adding that additional language, structure, device, it allows the courts a little bit more flexibility and kind of remove some of those hard-nosed arguments from some debtors who are really, really upset that they hit a sign and they don't want to pay for it. The third section that's being changed, and I think this is probably the biggest change in the actual bill, is the shifting of the language from just allowing for actual damages to allowing the use of estimated damages when seeking a judgment. Obviously, the intent of the Attorney General's office, as well as the Department of Transportation, is to seek as close to the actual damages as possible. But due to the amount of time it can take for construction work to happen, as well as the way that certain items are purchased by DOT, things being purchased in bulk, things being purchased at different times over extended periods, it can be very challenging, not impossible, but challenging to show the court this is the exact amount of damages for this specific incident. By being able to use the estimated costs, it gives my office more flexibility and allows us to actually show the debtor that we can get this resolved in a relatively quick manner. It isn't something that's going to take 6 months or a year of litigation as we pull together, numerous invoices spread across several years and start breaking down exactly where every single rivet and guardrail actually went to the state. So I'm available to answer any questions you may have, but that's all I have to say at the moment.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none, thank you. Next, we're going to go on to Stephen Bauer.
All right, thank you, Madam Chairwoman and members of the committee. I'm Steve Bauer. I'm the Executive Director of the Mortgage Bankers and Brokers Association of New Hampshire. And last year we had a Ron Study Committee bill that was not heard due to the abbreviated session. So over the summer, we formed our own task force, and the net result of that was that the bill that's presented, which is part 2, I'm sorry to mention, it's part 2, I think probably page 1 or 2, that we're all in support of this bill. And RON is the use of audio-visual technology to complete a notarial act when the principal is not in the same physical location as the notary public. RON is not to replace a traditional notary or electronic in-person notary. It's another tool in the toolbox that provides notaries the legal framework to modernize their practices to meet the evolving needs of businesses and consumers. RON's been enacted in at least 24 states. New Hampshire uses a variation of it in Executive Order 11, and an increasing number of states have proposed legislation. So my hope is that the committee will vote to move forward with this bill. Thank you.
Okay, thank you very much for your testimony, Mr. Bauer. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to go to Donald Sinkowitz.
Thank you, Madam Chair. Can you hear me?
Yes, we can.
Madam Chair, Senators, my name is Donald Sinkowitz. I am the most mispronounced estate planning lawyer in the state of New Hampshire.
Sorry about that.
Not at all. And I will be brief. I've only been on since 1 o'clock and it's been a longer day for all of you. I am testifying. I'm part of this working group of about 45 estate planning attorneys that Senator Whitley mentioned earlier today. My colleague, Virginia Sims Sheehan, Ginger Sheehan, may or may not testify because our working group's monthly meeting started at 4 and she chairs that group. And also our colleague, Representative Rebecca Macbeth from over in Portsmouth is also would have been testifying, but I think she's got a House exec committee that she's got to be participating in right now. And I am, and we all would have been testifying in favor of sections 2 and sections 7 of this bill. My colleague Benjamin Syracuse Hillman, I hope, will be testifying a little bit later about section 7. I'm not going to touch that. Section 2, you just heard from mortgage bankers and brokers, is about remote notarization, and we support that. And all we are asking for is a piece of language that is not in Senator Kavanaugh's part 2 to be added. And I've emailed that to all of you, and it's also in Ms. Horgan's inbox today. So what the state of affairs is, your committee was very helpful last July in getting enabling legislation, enabling us estate planning attorneys to do remote signings of wills, trusts, healthcare powers of attorney, and so forth for our New Hampshire citizens who were in the ICU with COVID-19 or in nursing homes and inaccessible by us, or simply homebound, bedbound, elderly, disabled, not driving. And that was essentially an experiment with an expiration date. So that legislation passed but it says to expire at the end of the state of emergency declared by the governor. And so all we're asking you to do is to remove that expiration clause. And so this is in the bill as proposed, section 2. It'll be on page 5 at the top. Let me just pull it up on my screen here. So if you want to look, sorry, page 2 at the bottom, there's section 7A. It says for the purpose of this section, but only in the context of executing an estate plan. So what we're asking you to do is on the top of page 6 of SB 134 as introduced, line 7, essentially striking almost all of line 7 and ending on the last day of the state of emergency declared by Executive Order 2020-04. So there, and in one other statute, again, this is in the Representative Macbeth was able to get Office of Legislative Services to draft up for the official amendment language. And I've emailed that to all of you and Ms. Horgan today. So we need, however the process works, and obviously we'll be grateful for any assistance to get those proffered amendments added to the omnibus bill. And all they do is take out the expiration date or the expiration mechanism of the end of the state of emergency in remote notarization of estate planning documents, and also remote witnessing of wills. Slightly different process. A will in New Hampshire requires 2 witnesses to be present, not a notary. And there's one other very minor language change, striking of the phrase power of attorney, in going back and forth with the members of the working group who are supporting the Rulona, Senator Kavanaugh's remote notarization, Uniform Real Property Electronic Recording Act. The concern was raised, well, powers of attorney are done in real estate closings, powers of attorney are done in estate plans. And so you'll see also, if you look at the OLS proposed amendment language, it strikes out. I said, fine, we can strike the reference to power of attorney. But that in essence is what we're asking, since I and several of my colleagues have determined that remote signing of estate plan documents during COVID-19 has been a very successful experiment. I've done a few dozen myself. I'm aware that the two largest firms in the states are using the process. We would like it to continue and that to be an option for New Hampshire citizens after the end of the state of emergency. And I'll be happy to take any questions.
Thank you very much for your testimony this afternoon. Senator Gannon has a question.
Just so witnessing is also in here?
Senator, it's not in SB 134 as proposed, but if you dig through your legislative email inbox or check with Ms. Forgan, our OLS proposal, it's a one-pager, has the change to RSA 551 and says essentially, as the statute says now, but only since July 17th, since midway through COVID-19, it says two witnesses who are being supervised by an attorney who's also a notary or a paralegal or under the supervision of that attorney, as long as those witnesses are on the same video meeting simultaneously with the testator, with the person signing the will, and that lawyer and the notary, then they are, quote, in the presence of. That's the legal questions. What does it mean to be in the presence of the testator when you sign as a witness? And so for COVID-19, we said it can be by video, and that seems to be working. So we'd like to keep that possibility open.
Okay. Follow up?
Yes, follow up.
So I'm just an old practitioner and I write a lot of wills. And so I appreciate the people at the table seeing that the person has the capacity to do what they're doing. And I'm just afraid you're going to get more fraud, and maybe that's just me. I'm all set. Thank you.
Okay, are there any further questions from the committee? Okay, seeing none, thank you all. Thank you very much.
My pleasure.
Next, we're going to go to Carol Willoughby. Good afternoon, Ms. Willoughby.
Ms. Willoughby, you are on mute.
Okay, why don't we come back to Ms. Willoughby? And let's move forward. Okay, let's go to Elizabeth Bilecki from the DMV. Good afternoon, Director.
Good afternoon, Madam Chair, members of the committee. Can you hear me okay?
Yes, we can.
Perfect. For the record, my name is Elizabeth Bilecki. I am the Director of Motor Vehicles. I am looking to testify on Part 11, which I believe is at the top of page 47. This is relative to employer access to motor vehicle records. The department is taking a neutral position on this part of the bill. We do believe that any changes to the driver privacy law really are a matter of legislative policy. New Hampshire does have probably the strictest driver privacy law in the entire nation. And it's true, been working with various companies that are looking to expand access to New Hampshire motor vehicle records. And we ask them legislative sense to be resolved that. Currently, the Driver Privacy Act is located in our C14. It does or access to motor vehicle records on a case-by-case basis. What that means, okay? Okay. I was just not getting a lot of head nods. What that means, the case-by-case basis means that in order to get access to someone's motor vehicle record, they have to obtain a written notarized statement from the record holder in order for us to be able to release it to an employer or a third party. What this law proposes is that motor vehicle records could be released to employers in a bulk electronic type of matter, where that consent would still be required. It would still be required to be notarized, but that consent would be retained by the person requesting the record, subject to auditing standards or practices by the DMV. There are a couple of concerns that I have with the language proposed, and I'll bring your attention to the top or to section, the second paragraph, section C of that bill, that states any person who makes a request under this paragraph shall have first obtained the written consent. The concerns that I have and we have is that it goes on to say that consent obtained pursuant to Section 18 of the U.S. Code, Section 2725 will meet this requirement. This particular federal law defines electronic signatures. The state has not adopted any standards for electronic records or electronic signatures. So adopting a federal standard before the state has a standard in place is a bit concerning for me. The second concern that I have is with the second section, section 2 of the bill, that strikes through a person and introduces the concept of an individual having access to motor vehicle records. It's critical to note that a person is defined within section or RSA 260.14. So there is a definition that says who a person is, and it defines an individual, it defines entity or an organization. So it's concerning that this definition, or it introduces the concept of an individual without it being defined. By currently having a person in there, it does allow us to release a motor vehicle record to a company that provides us with a written consent. I'm just afraid that if we change it to an individual, it might narrow down that particular authorization to really, truly individuals and not companies. I will leave it at that and see if there are any questions for me.
Thank you very much for your testimony this afternoon, Commissioner. Are there any questions from the committee? Senator Khan?
Thank you, Madam Chair. This is one that I was wondering, how do the companies currently access the information now?
Thank you for the question, Senator Khan. If a company is looking for a motor vehicle record of an individual, they need to obtain a written or fill out a written form, where the form would be signed by the record holder, it would be notarized and submitted to the DMV for us to release that record. The only exception to that is for CDL drivers, where the driver privacy law does have a provision to allow us to release CDL drivers' records to their employers.
Okay.
Perhaps Senator French is going to ask my question.
Senator French.
Oh, maybe, maybe not. So, Commissioner, thank you for testifying today. Who can the company share these records with?
Thank you for the question. Currently, the records cannot be transferred to anyone else. We do have instances where we will have or allow an authorized agent of an employer to obtain the records on behalf of the employer. In that case, they do have to provide us with a certificate of authority that states that they have the authority to conduct this particular business on behalf of a specific company.
Follow-up? And can you tell me, what is the penalty for a company sharing those records?
Thank you for that question. You're putting me on the spot. There is, I believe, a provision that there is a misdemeanor for willfully providing records to people that are not authorized to have access to that. But if you don't mind, I will provide you with a follow-up email to give that information to you. But there are provisions that have any person aggrieved by that violation, there would be some liquidating damages. But I will send that over to you directly out of the DPA right now, the Driver Privacy Act.
Thank you.
Okay, are there any further questions? Okay, seeing none. Thank you very much, Director.
Thank you.
Okay, next we are going to call, I'm looking for agency folks. Richard McNamara.
Yes, this is Richard McNamara. Thank you. I know it's been a long day for you. I am speaking on behalf of the judicial branch. I am a retired Superior Court judge. I retired in July of last year after serving for 11 years, primarily in Merrimack County. And I'm here to testify on behalf of our amendment to Section 5 of the bill, Procedures for Structured Settlements. I've been involved over the last few days with attorney Richard Head from the judicial branch who has assisted me. And I filed a memorandum, which I think you all have, because this is a complicated area. And I know it's been a long day, but I do want to explain a little background here. The judicial branch is concerned about making sure that New Hampshire citizens have adequate information before making what for many citizens is the most important financial decision of their life, transferring the benefits of a so-called structured settlement. Structured settlements occur in New Hampshire when a personal injury settlement is reached and the attorney recommends to his or her client that because of the client's life expectancy, it would make sense to have periodic payments made over the course of the person's life. These kinds of settlements are very common with minors who are going to live for a long time, with people who have catastrophic injuries who will need income in the future. There are three huge advantages to these sorts of settlements. First, obviously, the settlements can be paid out over time. Second, if a 10-year-old child gets perhaps a $50,000 settlement, has to be put in a custodial account, not much can be done with it. Basically, if the defendant purchases an annuity, that money can be professionally managed and pay out a very large amount of money in the future. Most importantly, the biggest benefit is the tax treatment. A personal injury settlement is not taxable. And the reason for that is because there's a loss of something that a person had. It's a recovery. And so on a structured settlement, the money accrues for many years and comes out tax-free. So it's an extraordinary benefit. Because these settlements are so valuable, they're often purchased by factors. There's a whole industry out there. They advertise heavily and they attempt to persuade owners of these annuities to sell them for far less than market value. In order to keep the tax benefits of the annuity, you have to comply with federal law. The Internal Revenue Code provides, this is all in the memo I gave you at 26 U.S.C. 5891, that the transfer must occur pursuant to a qualified order. And the qualified order is defined basically as an order made pursuant to a statute which relates to these kinds of transfers. And if the state doesn't have a statute, as New Hampshire doesn't, you use the statute of the state in which the company where the annuity is domiciled. So New Hampshire judges for years have been handling these kinds of transfers using a statute which is essentially identical to the cognate statute which appears in the bill. So the proposed statute as written really wouldn't change the law at all. The problem that the judiciary faces, and this has been a problem, the reason I'm speaking to you as a retired judge is I took the lead in drafting a statute last year, which didn't make it through because of the COVID business. And the Superior Court is very concerned by the fact that we often face cases in which unrepresented and unsophisticated individuals seek to sell their annuity and be taken advantage of. The New Hampshire Supreme Court has recently considered the language of the federal statute. The key language is in Section 5. The judge has to find that the transfer of the structured settlement to the factor, to the person buying it, is in the best interest of the payee, taking into account the welfare and support of the payee's dependents. That's a federal standard. If the judge doesn't make that finding, the tax benefits don't work. The problem is that standard is very broad And what it means is that the court simply has to make sure that the defendant, that the person selling the annuity isn't impoverished. The court is not allowed to substitute its judgment for the consumer. What brought this to a head, I think, is a case called Blazing Star Funding versus Wilson, a 2015 decision of the New Hampshire Supreme Court. This statute and the statutes of all states require disclosures. The person buying the annuity has to disclose to the often unrepresented seller what the discount rate is, how much he's giving up, that he has the right to talk to a lawyer. But most of these unrepresented individuals never do. In the Blazing Star case, the facts of that case show that the person selling the annuity was going to receive $125,000 in exchange for payments. This was in 2015 of $400,000 due in 2023 and 2028, which had a present value at the time they were being sold for $125,000 of $298,000. So in other words, those benefits were being sold for 41 cents on every dollar. And a judge really has no right to tell a person what to do. The New Hampshire Supreme Court has made it very clear in the Blazing Star case. At the outset, we note that regardless of the trial court's personal views of companies that try to bust structured settlements, the right of private parties to enter into enforceable contracts is a constitutionally protected decision. The court went on to say that Wilson, the plaintiff, had no dependents, and he had been successful working. He had the ability to care for himself, and the court reversed the trial judge's refusal to allow the sale to go forward. And I think that is obviously the correct decision. Judges are not Platonic guardians. We don't get to tell somebody, well, you want to buy a car, you shouldn't buy a Cadillac, you have to buy a Chevy. It's up to them. But it is pretty obvious that most people who sell these structured settlements see a lot of advertising, and they don't really have the ability to look at this market. Most people aren't even aware of what a factor is. They see an ad on TV saying it's your money and they can sell it, and they take whatever they can get. So the judicial branch's proposal is to let the market work in favor of New Hampshire consumers and get consumers more information, just the same as most consumer protection acts like the Securities and Exchange Commission. And our proposed amendment in Section 5, which you will see, is very simple. In addition to the court making findings that the transfer is in the best interest of the payee, and that the payee has been advised in writing to seek independent advice, that's already done, and plaintiffs always tell you they don't want independent advice. The key is the payee presents 3 separate bids for the structured settlement right. Each bid shall be made by organizations which are unaffiliated with each other in any way and cannot benefit from each other financially. And the presentation of these 3 bids can be considered by the court, but is not dispositive. And the court can waive the requirement for good cause shown. The idea behind the statute is, because in the real world, I can tell you as a judge, these factors have very sophisticated lawyers who do nothing but put the documents together to make a lot of money off unrepresented plaintiffs. And they'll come in with a sheet of papers and say, sign here. And one of the things will say, you have the right to go see an attorney. Here's the discount rate. They will also have to tell them, well, you have to go get 3 bids. And then they get online and they can go looking. And when they get those 3 bids, the odds are pretty good. They'll be able to get more money. The market will put them in a better spot. It's a chance for the free market to work to the benefit of consumers by simply providing them information. It does not put judges in a position of imposing their values on people and taking people's rights away. Rather, it's consistent with the idea of full disclosure, that best decisions are made when people have a good disclosure. So I know that my former colleagues feel strongly about this. I put a memo together, which you have. I know you're tired. I know it's been a long day. And I'm happy to answer any questions. Senator French.
Thank you very much for your testimony. Senator French has a question.
Thank you. Thank you for taking this. So a structured settlement is an individual's asset once it's been granted, correct?
Yes, sir.
So why would we stop at structured assets for court intervention and not go for the liquidation of real estate, bonds, or any other asset an individual might have?
Well, because there's no statute requiring, first requiring that a court find that the sale of the asset, the transfer, is in the interest of the consumer. Second, I think the average person, a good example is buying an automobile. Nobody goes to one dealership, walks in and buys a car. They go look at other cars and they go look at other dealers selling the same car. Or when they get a loan, the interest rates, the information is all spelled out. It's not all that the person has to do is get some bids. And the point is that it is the buyer of the annuity who has the market power who has to tell the consumer that, say, go out and get a bid. And then it's all up to the consumer. He can take whatever bid he wants. He can take the lowest bid. But by providing more information, I can tell you as a judge, I'm retired now. I retired at the mandatory age of 70. I would see things that were just horrible. People really taken advantage of. And this is one way in this very arcane area where people don't understand this whole process, where in the real world, they have an opportunity to get a better deal. That's what this is about, Senator.
Okay, thank you.
Are there any further questions from the committee? Senator Gannon.
Thank you, Judge. What if we just, real simple terms, you went with a reasonable agreement? That would give you, you're a court sitting in equity. You could decide if it's fair, 40 cents probably isn't fair. 75 cents on the dollar. You're sitting there, you have some discretion. Reasonable agreement. Simple.
Well, Senator, I think the problem with that is you could get very philosophical and say that our legal system is based on a John Locke Aristotelian theory and that we're not Platonic guardians. It isn't a judge's job to decide what's fair or not fair. And that's what the Supreme Court really said. The Supreme Court said precisely that in the Blazing Star case. It said that, and I'm quoting the language, it's in my memo, and I know you're an attorney, the Senator, you'll see it. This is a quote. At the outset, we note that regardless of the trial court's view of companies that try to bust structured settlements, the right of private parties to enter into an enforceable contract is a constitutionally protected interest. The trial judge who handled the Blazing Star case felt, I think, as many of us did, he just felt it wasn't fair. And the Supreme Court said, you can't do that. That's not what we have judges for. People have rights. People have the right to make their own decision, even if it's a bad decision. And so the Superior Court would like to just get them good information. So whether they make a good or a bad decision is up to them. But in this area that is a very difficult area, most people don't know anything about structured settlements and why they're so valuable because of the tax consequences and why people would want to buy them. This is just a way to provide information, Senator.
Thank you.
Okay, are there any further questions? Okay, seeing none, thank you very much for your testimony this afternoon.
Senator Carson?
Yes?
Miss Willoughby was having difficult calling in, but she is now on a computer. I don't know if we should go back to her.
Yes, why don't we go ahead and do that?
So it looks like since she's using an older version of Zoom, we would have to promote her to a panelist. Jenny, okay. Miss Willoughby? Are you there? No. Doesn't look like it's working.
So I think, Senator, we're going to have to kick her out and see if she can get back in, because we'll have to remove her as a panelist. We do have to kick her out.
Okay, all right. We'll keep trying. If not, we're going to have to figure something out, because she has the right to testify in front of the committee. And if there's some technical difficulties, we need to figure out what we need to do at that point. Okay, next we're going to go to Benjamin Hillman.
Hi, can you hear me?
Yes, we certainly can.
Great, thank you. Hi, I'm Benjamin Syracuse-Hillman. Thank you, Senator Carson and members of the committee. And thank you, Senator Whitley, for introducing this bill, both to the, in both senses of the word, I guess. I'm Ben Syracuse-Hillman. I'm an attorney at Shaheen and Gordon. And together with a group of about 45 trust and estates lawyers that work on legislative issues, and in consultation with a number of others, we drafted some language that ultimately became part 7 of this bill, as well as, and it was actually 2 bills in the last session, but is now combined here as part 7. So I want to talk a little bit about this language and what it would do. I'm mindful of the time, because I know this has been going on for a long time, and also that this was discussed in this committee last year. So I'll try to be a little bit briefer than I was last year, but if folks have questions, of course, I'm happy to take them. So the bill, just to start, has the general support of the Trust and Estates Bar, and on behalf of the probate judges, Judge David King, who's administrative judge of the Circuit Court, reviewed, provided feedback on, and supports the changes to the waiver of administration portion of the bill, and did not comment on the other aspects of the proposed legislation. So first, the first section deals with expansion of availability of the waiver of administration process in uncontested estates. This bill would simplify the probate process in many cases by expanding the existing waiver of administration process, which under current law applies to certain estates where there both is and is not a will. But the situations are fairly limited. It generally only applies when you have only one beneficiary of an estate, and that person is a spouse, a child, or a trust. This process first came into New Hampshire law effective January 1 of 2002. And since that date, its applicability has been expanded on a couple of different occasions. But it still does not apply in the circumstance where there's more than one beneficiary, even if they all are on the same page, or where the sole beneficiary of an estate is someone other than a spouse, child, or trust, such as a sibling, friend, or unmarried significant other. And the bill proposes expanding the applicability of that process to include all estates where there's only one beneficiary, and that beneficiary is serving as the administrator. Or where there are multiple beneficiaries, and those beneficiaries are all co-administrators, or they all sign an assent to the appointment of an administrator, as well as where it's otherwise appropriate in the discretion of the court. Where waiver of administration applies, the probate process is simplified. Under the regular probate process, an inventory has to be filed, a bond has to be posted in estates with a value of $25,000 or more, and the estate must be closed with either a final accounting or a motion for summary administration. Under the waiver of administration process, the paperwork to initiate estate administration is the same. That is, it's the filing of a petition and requires all the same information, whether it's the waiver or the regular process. But no court-filed inventory, bond, or accounting is necessary. And instead, the estate is closed by the filing of a waiver of administration statement at any time after the 6-month creditor claims period has run. And this statement under oath includes a certification that all creditors have been paid. Again, this would not, the proposed bill would not change that existing process. It would just expand its availability to a broader range of uncontested estates. And the regular probate process, of course, remains appropriate in contested estates or those where there's simply a lack of trust between beneficiaries. And in such estates, the inventory and accounting requirements provide transparency and an important opportunity for a beneficiary to challenge an administrator's actions. And as such, under the proposed bill, where there is more than one beneficiary, waiver would only be available where there is unanimous consent of all the beneficiaries to agree to serve as co-administrators or to assent to someone serving as administrator, either one of them or a third party. And the proposed bill would also maintain the provision in current law that any interested person can petition for full administration at any time while the estate remains open. And so these provisions would ensure that in contested estates or where there's simply a lack of trust, any one beneficiary or any one interested person has the ability to require, it's still up to the court, but essentially to ask the court to have the full traditional estate administration process apply. But in the vast majority of those estates that are uncontested, significant time and resources will be saved by allowing the waiver process to be pursued. And I believe the saving would accrue both to the estates and the beneficiaries of those estates, and that they wouldn't need to prepare or pay someone to prepare and file unnecessary paperwork. And also to the court system in that judges and clerks will not need to review paperwork or hold hearings to address issues when the paperwork is improperly filed or otherwise, there are a lot of cases, particularly where people are pro se in administering estates, where there's it's a tricky process and there's a lot of clerical errors and mistakes that lead to a lot of process that can probably be avoided. And judicial resources can be focused on those estates where court oversight and or intervention is needed. Importantly, creditors will retain all the protections they have under current law, including a 6-month period during which assets can't be distributed to beneficiaries, the right to seek full administration, and the protections of the insolvent estate process where the assets of the estate are not adequate to pay debts. And the bill also makes 2 other helpful changes. It explicitly allows the court to grant an extension to what is right now a 1-year deadline to file an affidavit of administration in those estates that take longer than a year to administer. Under current law, it's not clear, and different judges have taken different views in different circumstances. And this is actually something requested by Judge King to kind of clarify the judge's authority to extend that deadline. And the other important piece is the bill makes clear how deadlines operate if an estate that starts out as a waiver of administration is subsequently converted to full administration. And that's something that's also not clear under current law and has sometimes resulted in inconsistent application and confusion. So that's, sort of covers the waiver provision. Section 3 resolves an ambiguity in the intestacy statute with no substantive change intended. Section 4 deals with the Uniform Power of Attorney Act. This is RSA Chapter 564E, which became law on January 1st, 2018. And it amends the act to take into account experience practitioners have had with the law over its first, 3 years of existence. It amends the agent acknowledgement form by adding clarification that more accurately reflects the agent's obligations under current law without any intended change to the governing substantive law. That's Section 4. Section 5 of the bill adds a reference to a provision of the revised Uniform Fiduciary Access to Digital Assets Act, which became law in 2019, and governs what a custodian must do when a power of attorney expressly grants an agent authority over the content of electronic communications. And so by incorporating the reference here, it makes clear the authorization given in the power of attorney is what is, set forth and fleshed out more fully in the other statute. Section 6 clarifies the use of the term gift, again, without a intended change to substantive law. Section 7 amends the statutory form in several respects to make the form clearer and easier to use, and eliminates a section that is confusing and didn't accurately reflect New Hampshire law. That was the current Section 6 of that form, and replaces it with a series of more specific options, allowing a principal to specify the manner, if any, in which an agent may benefit him or herself, or those whom the agent owes a legal obligation of support. Provisions in a financial power of attorney allowing an agent to benefit him or herself are essential in some situations, but unfortunately provide opportunities for abuse in others. And the proposed changes to the statutory form provide some more specific language and more choices to the person signing the form, the goal being to maximize flexibility and minimize the opportunity for abuse by empowering users of the form to make deliberate, specific, and if desired, narrow choices appropriate to their situation. And then finally, the next part of the section, part 7 rather, which Section 10, the Uniform Disclaimer of Property Interests Act. This was a separate standalone bill in the last session that passed. This substantially updates the current Uniform Disclaimer of Property Interests Act, RSA 563B. The current act was enacted in 1996 and has not been amended since. This proposes to update it with the new Uniform Act. There are a few changes that are specific to New Hampshire. As Senator Whitley noted, specifically, it includes changes requested by DHHS to try to avoid some potential abuses of disclaimers where it impairs estate recovery or could impair estate recovery. All of the DHHS requested changes are in the proposed bill. In summary, it expands the prior definition of disclaimer to include a broader range of property, provides further and more specific instructions to clarify when a disclaimer is delivered and under what circumstances it becomes effective. It clarifies the result of refusing property or powers through a disclaimer. It creates rules for several types of disclaimers that are not explicitly addressed under current law, and provides rules for when a fiduciary can disclaim. It allows a partial disclaimer, and it clarifies that the disclaimed interest passes without direction by the disclaimant. And I'd add 25 jurisdictions have adopted this model act in whole or in substantial part. And we do have the model act in New Hampshire law now, but it's a prior version that again is over about 25 years old at this point. I think I'll stop there. Thank you for listening at the end of this long day, and I'm certainly happy to take any questions that anybody has.
Thank you very much for your testimony, Mr. Hillman. Are there any questions from the committee? Okay, seeing none, thank you very much.
Senator
Okay.
Carson,
Yes,
I'm sorry, Ms. Willoughby did try to call back in. I don't know if you want to.
let's give it a shot. We've got to keep trying. We've got about 9 other people who are on the list to testify.
So Ms. Willoughby, to unmute, you have to press *6.
Ms. Willoughby?
Good afternoon.
Yes.
Good afternoon. Hooray. Success.
Good afternoon. Thank you so much. It's a little embarrassing to call in and speak about a bill that promotes technology when you aren't using it successfully yourself. So thank you for your patience. Madam Chairperson, Mr. Vice Chair, members of the committee, really appreciate the opportunity to testify today. My name is Carol Willoughby. I am employed by First American Title Insurance Company. I serve as Vice President and New England Regional Underwriting Director. I'm a licensed attorney in good standing in New Hampshire, and I am speaking to Section 2 of the bill, starting at page 3. First American is a leading national provider of real estate settlement services and a major consumer of notary services. And in my capacity there, I monitor important legislation impacting the real estate industry, oversee development of underwriting protocols, and underwrite thousands of commercial and residential real estate transactions throughout New England each year. I'm also a member of the stakeholder group, and I was involved in the drafting of the bill. Again, many thanks for letting me, on the third try, get in. And finally, as a constituent of Senator Kavanaugh, many thanks to his office for providing information, keeping me updated on progress, and for sponsoring the section of the bill. I'll refrain from reading my written testimony. You have it in front of you, and instead I'd like to direct my remarks to just some key points about notarization, remote online notarization, and Section 2 of the bill itself. Please note that the bill seeks to enact remote online notarization, and at times you will hear it referred to as RON. That's a term of art commonly used. I don't want to confuse anyone. In addition, if I refer to notaries, I'm referring to anyone authorized to perform a notarial act under the laws of New Hampshire. Certainly the past 12 months have taught us nothing if they have not taught us the value of technology and the importance of its use to serve our citizens, to work, obtain the daily necessities of life, food, clothing, education, provide health care, and the ability to connect with our families and friends and to conduct business. But every day, thousands of New Hampshire citizens need to conduct certain activities that require notarization and similar services, and this is an historically face-to-face service. We've been fortunate to have use of the tools provided by Governor Sununu's Emergency Order 11. but our citizens need a more robust and permanent solution. I'd like to comment briefly on the importance of notaries and notary services. Notaries, as you may know, perform a variety of tasks which serve as the foundation to the reliability of our real property land records and which are critical in our legal system as a whole. Among other tasks, those services include taking acknowledgments and administering oaths. And when performing these services, the notary serves three critical functions. They confirm the signer's identity, they confirm that the signer knows what they're signing, and they confirm that the signer is acting of their own free will. The notary typically does this reviewing a government-issued identification credential presented at the time of signing and through a few formal or informal questions designed, if you will, to elicit a conclusion that the person does in fact know what they're signing and they're doing so of their own free will. And this is, of course, out of the context where the notary has, personal knowledge of the individual. As such, notarization, if it's done properly, is a significant and important safeguard to fraud. And in the real estate industry, it is a core vehicle upon which we rely to establish those land records and the validity of the legal documents through which we buy and sell real estate, grant mortgages, easements, and other things. It is a linchpin of our land record system, and I'm sure it serves equally important foundational purposes in other settings. Section 2 of Senate Bill 134 seeks to bring in, quite simply, an additional optional method of performing these services remotely online. And this is specifically spoken to at page 7, line 5 of the bill, and those lines thereafter, of course. And with that in mind, I'll turn to the elements of a strong, safe, remote online notarization law and why I believe that Senate Bill 134, Section 2 fits the bill, for lack of a better pun. Without that face-to-face in-person interaction by which a notary can judge these important facts, how do we create that same faith, that same reliability, and protect our citizens from fraud in a system of remote notarization? Well, there's three ways, really. There's enhanced identification protocols, there is a robust audit trail, and there's secure technology. RON technology platforms and Section 2 of Senate Bill 134 provide all three of these safeguards and more. Both use enhanced identification protocols that establish the signer's identification credential and is performed using online data that's verified. Using the ID itself is credible, and establishing that the ID itself is credible, that it's not fake, that it's not expired, and it is issued to the signer. It allows the notary the opportunity during the signing session to also view the credential and to look at the person who has tendered it. And it retains a record of verification of that identification credential. In addition, it utilizes dynamic multi-factor authentication, which is based on public and private data sources. And that involves out-of-wallet questions that only the signer would know. Objective, data-based, and they are generated in such a way you cannot know the questions in advance. Of course, there are abilities to retest. Both Senate Bill 134, Section 2 and a robust Online Notarization Act require an electronic record of the notarial act itself. There's this required audio-video recording of the notarial act, not of the NPI that's used to authenticate the signer's identity. And this assists in verifying, obviously, the signer's actions in the event of a future challenge. They provide that ability to review the recording together with documents executed through that online signing, both immediately and in years to come. In addition, the fact that the notarial act is undertaken remotely is evident in the body of the notarial certificate as a disclosure. And this means that the document itself on its face reveals the method used, and the acknowledgement can be evaluated on that basis for reliability as well. We're able to immediately identify the protocols used in verifying the signer's identity and the actions that are undertaken. Both a good robust online notarization bill, law, and Senate Bill 134, Section 2, require the use of tamper-evident technology. And this means that remote online notarization contemplates the use of an electronic record, if you will, to which is applied an electronic seal. And that is detectable if someone tries to alter the document. The notarial act is undertaken via secure online communication technology. So all of those elements are used. You have already heard today from a couple different sources that notarization has been the subject of significant legislative efforts over the past 3 years. As of the current date, in actuality, there are 29 states that have enacted full remote online notarization. There are 11 additional states, including our own, that have permanent RON legislation pending, and additional states where there are stakeholder activities at play to bring RON legislation into being. Without its own robust remote notarization law, New Hampshire citizens are really at a disadvantage. We are a cross-border society. People work, invest, travel, etc., across jurisdictional lines. Without properly drafted laws, our citizens are left to seek online notarial services out of state. And if not properly legitimized by our laws, there's the risk that a court could rule the document invalid. And these are documents which we need to be able to rely on. In addition, rural and underserved communities have better access to notarization, as will those without ready access to transportation, those working and serving in other parts of the country and the world, and of course, in situations such as the current pandemic, those who are similarly impacted when health and safety would suggest they should not go out. So in sum, Section 2 of the bill quite simply provides an additional optional method of performing a notarial act remotely, not in the physical presence of the signer, in a secure online fashion. It doesn't take away the current historical method of in-person notarization. And for all of the reasons given, plus those that are in my written testimony, I appear in support of Section 2 of the bill, and I'm happy to take any questions.
Senator Carson, you're on mute.
The dog was crying, so I had to turn it off. Thank you very much for your testimony. Senator French has a question.
Yeah, thank you. Thank you, Madam Chair, and thank you for testifying today. Do you think maybe in 1840, when they came up with the way to do this, if we had the same technology we had today, probably we'd be doing it this way?
I'd hate to guess what we would have done in 1840, but I would like to think that if we had the technology, yes, that we would utilize it.
Great, that's what I was thinking. Thank you.
Hey,
You're
are there
welcome.
any further questions? Senator Gannon.
Do you think I'm a notary?
Yes.
And I'm old fashioned. I've been doing this too long. And I just feel when I've been at wills when I wouldn't record them, I wouldn't notarize them, because I could tell when I talked to them and I could see them and I could see someone trying to hold their hand and write the signature. It wasn't the proper thing to do. I'm afraid I'm going to lose some of that. And I understand totally in the emergency with COVID, but do you think
Sure.
your remote is going to be as safe as in person?
I think that's a fair question and an excellent question. I think, number one, it's an option. It's not required. And no notary that is using that system is required to notarize the document if they are not comfortable in that situation. As you've indicated, I too have been a notary and have refused to take acknowledgments. But the beauty of the system is it does provide real-time visual communication, audio-visual communication. It doesn't take away the ability of the notary to, have that conversation so that you do, feel comfortable that they do know what they're doing and that they are doing so of their own free will. Sorry, go ahead.
No, I was saying I'm good. Thank you.
You're welcome,
You
sir.
can finish though.
Okay, thank you very much. Are there any further questions? Okay, seeing none, thank you very much, Ms. Willoughby.
Thank you.
Next, we're going to hear from Jack Kelly.
Thank you, Madam Chairman. Can you hear me?
Yes, we sure can, Mr. Kelly.
Thank you, Senator. I'm Jack. My father's Mr. Kelly. But thank you very much. I'd like to thank the members of the committee for taking the time to hear me out. I'm here on regarding Section 5, which is the structured settlement transfer provisions. Today, I will be joined at other points by Mr. Brian Deere, who is with the National Association of Settlement Purchasers, and our colleague, Mr. Craig Ullman, a partner at Hogan and Lovells, and representing the National Structured Settlement Trade Association. I am a partner at the McPherson firm in Washington, and I am representing the National Association of Settlement Purchasers.
Mr. Kelly, before you go on, just make sure that whoever is speaking identifies themselves for the record so we can get their name and who they represent.
I appreciate that, Senator. We'll note the record as we appear. I was just trying to lay the foundation. Today, all of us are here in support of the New Hampshire adopting the Structured Settlement Transfer Act. New Hampshire will be the last state in the United States to adopt this act. 49 states and the District of Columbia have adopted this law over the past 20 years since it was created. I'd like to give you just a brief history of the structured settlement and why it exists and why we are here today. I myself am a former staffer at the House Ways and Means Committee in Washington, where we created the structured settlement purpose. In the 1970s, when we created the Structured Settlement Act originally, it was a tax provision, and it was designed to benefit those individuals who needed long-term care and could have the benefit of the tax afforded to it and the treatment afforded to it. As time went on, structured settlements were no longer being used for the purposes of long-term care and for the continuation of care. While they are still used on occasion for that, they're often used for settlements of torts involving simple things like a slip and fall or some sort of an assault or some sort of a harassment issue. And as such, individuals, a market arose where structured settlement recipients, the people who received the structured settlements, wanted to sell their asset because they wanted to have access to this asset they have. And so emerged the structured settlement purchasing market. In 2002, after the tragedies of 9/11, Congress was considering the Victims Act of 9/11, which was a structured settlement legislation, in effect, structured settlement of the victims of the tragedy of 9/11. And at that point, they chose to clarify the law and to ensure a transaction and to ensure a procedure where people could transfer their structured settlement or sell a portion of this asset to gain access to cash. But they wanted to ensure in doing so that the individuals were protected in this process. And they created a statutory mandate that the individual must go before a court in their jurisdiction, and they must have it reviewed by a court, and they must determine that it's in their best interest that this transaction occur. And it's not only in their best interest, but to take into account the welfare and support of the payee's dependents and to make sure it doesn't contravene any other federal, state, or local law or the order of any court or authority. In doing so, Congress looked at this and said, we are saying we want to protect the rights, but at the same time, we want to give people the ability to access the asset that they have. In clarifying it, it required the states have such laws. In 2004, the National Conference of Insurance Legislators chose to adopt a model act that would provide for a uniform system to comply with this federally mandated requirement to review these orders. That model act has been reviewed 3 times since its initial enactment, only as recently as a few years ago, updating it and applying it uniformly. Today, we are here before you because the purpose of this law is New Hampshire does not have such an act. This law is a well-established civil procedure that has worked for over 20 years in the states across the United States. As I've noted, it requires that the structured settlement recipient have to go to a court to have it approved, that they sell their asset and it is there in their best interest that it be done. That court has every ability to determine and inquire and ask that individual when they appear before them all the queries that are necessary and testimony necessary to determine if it's in their best interest. And that is regularly done. It requires that that individual appear in person and it appear in their local county. This avoids the problem that New Hampshire has today. For if New Hampshire today does not adopt this law, New Hampshire will operate under the process that operates today, which under the federal law says if New Hampshire does not have a law, then the judge has to rely on the law of the state in which the annuity carrier is located. So you could have an individual who's from Epping, and they have to go before a court. But that insurance carrier is Pacific Life in San Francisco, California. That New Hampshire resident is now subject to the rules of the California law, not the New Hampshire. There's no law in New Hampshire to govern them. And in fact, if it requires their personal appearance, they have to physically go to San Francisco to be heard, unless the court waives their personal appearance. That, I don't think, is what you want for New Hampshire. This is a robust, well-established bill. Let me tell you something. It provides very clear transactional documentation that's transparent, telling the individuals all of the facts surrounding the transaction. In addition, it requires that the individual know what they're doing. And that's what's most important. This is an asset. This structured settlement that this recipient has is an asset, and if they desire to sell it, they should have the right to do that. Now, there has been discussion here today about by the Honorable Judge McNamara raising the concern of a desire for 3 bids. On its face, this does sound like an interesting proposal, but this issue has been often raised in other jurisdictions. There are a number of reasons why it's been viewed as not a solution. We, as you will note, and the chair, I think, will inform you and staff will inform you, have provided an amendment that we think addresses the concerns of Judge McNamara, that requires that the individual be informed that they have had the opportunity and are advised to get 3 bids, but it does not statutorily mandate it. These individuals and these structured settlement recipients have the right under the law that will be before you today, the legislation, at any time they have a right of rescission to walk away from the transaction, right until the point in time that the court issues the order. What transactions have that length of time for an individual of a right of rescission? When an individual is forced to go out and seek additional bids, it first of all doesn't even take into consideration that that individual, more than likely, if all these advertisements are out there, hasn't shopped around. Just like the Honorable Judge has said, just like when you buy a car, you shop around. They have gone out and shopped around. But if you require them to go out and do such, they will then have to go to 3 companies who they may or may not know and provide that individual with all their personal information, all their medical records, all the information associated with it. And now, as we know, the challenges that are associated in the world of privacy, your records are all out there. That individual then, once they have that information, they may be contacted on numerous bases to buy or sell other options or other products. I don't think that's the intent here. The intent here is in this well-established model act that's been adopted across the nation. We're asking that New Hampshire adopt the same law. It works well. And I urge the committee to approve the Structured Settlement Transfer Act, and if necessary, with the amendments that have been proffered, so that New Hampshire residents have an equitable ability to be able to sell their assets with judicial review determined in their best interest. I'm happy to answer any questions from the members of the committee.
Thank you very much for your testimony, Mr. Kelly. Is Mr. Ullman available, and would he like to speak?
Yes.
Okay, let's get Mr. Ullman up and going.
This is Craig Ullman. Can you hear me?
Yes, we can.
Okay, thank you. Madam Chairman and members of the committee, my name is Craig Ullman. I am with the law firm of Hogan Lovells in Washington, D.C. We are general counsel to the National Structured Settlements Trade Association, whose members include insurance companies that use structured settlements to settle claims against their insureds, life insurance companies that write annuity contracts to fund structured settlements, and licensed insurance brokers who specialize in putting structured settlements together. Back 20 plus years ago, I made a serious career mistake of drafting the model legislation that is the basis for the now 50 existing state statutes to which Mr. Kelly alluded. What I'd like to do is focus a bit more on what Judge McNamara has told you and the reasons why we believe the amendments that the proponents of Part 5 of Senate Bill 134, which begins, I believe, at about page 15, believe the appropriate response to the judicial branch's concerns. I should mention that the proponents, this is unusual legislation in that you have squarely in support of it, you have both the settlement purchasers represented by Mr. Kelly, you have the people who put structured settlements together represented by me. You also have the life insurers, the American Council of Life Insurers. You have the property and casualty insurers. You also have the trial lawyers, all in support of the same legislation. That's an unusual coalition, but it has come together because, frankly, we have legislation that has been road tested in 50 other jurisdictions. Now, as Mr. Kelly said, the judicial branch proposal of mandating that people get 3 bids sounds on its surface like a good idea. And the proponents don't disagree that it is a good idea to tell payees, tell settlement recipients that they have the right to negotiate the purchase price and that they are advised to obtain competing offers. We think it's also a good idea to tell courts that when they are making this critically important decision about whether a sale of settlement purchase rights is in the best interest of the payee, taking into account the welfare and support of the payee's dependents, that the court can appropriately, it should take into account whether the payee has obtained competing offers. But a mandate goes too far. And Mr. Kelly suggested one of the reasons for why it goes too far, and that is the privacy concerns, which are serious. But let me give you 2 more. One is timing. Often people are selling their structured settlement payment rights or proposing to do so because they are facing desperate financial circumstances, a foreclosure, for example. And the fact is the timing of these SSPA proceedings, as we call them, automatically builds delays into the process because it is a court approval process. And if people have to get additional competing bids, that builds additional delay into the process, particularly, well, I'll come back to a reason why that may be even exacerbated. The other reason why mandating competing bids is not such a great idea is that the fact is, as Judge McNamara pointed out, where are people going to go to get competing bids? Well, the likelihood is they're going to get on the internet and see what that produces. A, they'll have to provide confidential information, but B, in many cases, they will end up getting bids that are effectively meaningless because they don't know who's behind those bids. The judicial branch proposal suggests that the bids have to come from organizations, I'm quoting here, that are affiliated, that are not affiliated with each other in any way and cannot benefit from each other financially. Well, how's the payee supposed to know that? The settlement purchasers often have multiple affiliates. They've got a lot of interconnections, and there's no way on earth for a structured settlement recipient or a court to know that that's the case. And in many cases, they'll get bids that look as though they are, in fact, independent and competing, but they are not. We've discussed this with Judge McNamara and Richard Head, and in fact, the amendments that the proponents have suggested, we provided to them, and we said we didn't think that their approach was appropriate. We raised our objections, and their response to that was to suggest, oh, well, that can be cured by adding a provision, and you'll see it in their draft amendment. The court may waive the requirement for 3 bids for good cause shown. But guess what? That waiver would have to be provided in response to a request from the settlement recipient. The very settlement recipient that Judge McNamara has characterized correctly as unrepresented, which is true in virtually every case, and unsophisticated, which is true in many cases. So the settlement recipient would have to be going to court and requesting a waiver, and that then builds additional delay into the process, even if you have a settlement recipient who can do that, because what happens if the waiver is denied? Then the settlement recipient has to go back to the drawing board, and that takes even more time, and maybe the house gets foreclosed on while all of that is happening. So that's why we don't believe mandating 3 offers is the appropriate solution. But the fact is, what we have tendered, what the proponents have tendered in these amendments is in effect in several other states where this issue has been raised, and it appears to work. It gives the payees a reminder that they can negotiate. It gives the court a specific indication that it should inquire into whether the payee or the settlement recipient has obtained competing bids, and we think that's the appropriate solution to the problem. I should mention one other point. Judge McNamara cited several times the Blazing Star case, an unreported decision of the New Hampshire Supreme Court, and he cited to you what is probably best described as a rhetorical flourish in the decision about the court not standing in the way of the payee's right to dispose of his property. But the fact is, that's not the holding of the case. The holding of the case was that the Supreme Court, I'm quoting here, cannot determine upon this record whether the trial court could reasonably have found that the transfer was not in Wilson's best interest, that is, the settlement recipient's best interest. So the Supreme Court remanded the case, and ultimately the trial court approved the transfer. The fact is also, in that case, the structured settlement payee, as the decision recognizes, was actively negotiating with 2 different settlement purchasers. It's reflected in the record. So in that case, you had a settlement recipient who was capable of negotiating a deal for himself, and would it have made sense to mandate that he either get a 3rd offer, or alternatively, that in order to avoid that mandate, that he go to court and request that the court grant a waiver from the requirement? So I don't think that the Blazing Star case, insofar as it sheds any light on this, I think it suggests that the proposal that the proponents have made, the proposed amendments, are an appropriate answer. I applaud the judicial branch for raising this issue. I think that the statute with these amendments would be an improvement on the statute, or on the proposed statute as introduced, or the bill as introduced. But I think those amendments go far enough, and the judicial branch proposal simply goes too far. With that, I've probably filibustered too long, but I'll be happy to answer any questions.
Thank you very much. I'll make sure that I'm not, okay. Thank you very much for your testimony. Is there any questions from the committee? Okay, seeing none. Thank you, Mr. Kelly, and thank you, Mr. Ullman.
Thank you, Madam Chairman, and thank the committee for their time and effort today.
Thank you. Next, we're going to go to Ken Norton.
Thank you, Madam Chair and members of the committee. Appreciate that you've had a really long day. I'm here to testify on Section 9, the mental health intervention training. And just by way of background, I've served on the governor's LEAC commission this summer, the Law Enforcement Accountability, Community and Transparency Commission, and also on the governor's commission on courts and corrections. This bill came about, and I thank Senator Guida for sponsoring it, and Senator Carson for sponsoring including it in the omnibus bill. It came about following a number of discussions regarding the use of deadly force and officer-involved shootings. A report from the New Hampshire Attorney General's office in 2016 indicated that 45% of the officer-involved shootings in New Hampshire involved a person with known mental illness, and that's significantly higher than the national average of about 25%. Subsequent to that, I've had many conversations with Attorney General McDonald and with other folks, the governor's office, Commissioner Quinn, Commissioner Bartholms before that, and policy leaders around the state about how we can address this in New Hampshire. NAMI New Hampshire received a 3-year federal grant to provide crisis intervention team training, which is a 40-hour training to the New Hampshire Department of Safety and State Police. And the training is based on, it's called the Memphis model. It's an internationally recognized training, and it involves a use of, we have over 20 subject matter experts that are part of the faculty, as well as trained actors who are people with personal lived experience with mental illness, either themselves or as family members. And role play and rehearsal is a significant part of the training, so that a role play might be an individual where law enforcement is called to someone who is locked in the bathroom and who may be engaged in a suicide attempt, and law enforcement is on the other side trying to get them to open the door. Relative to the use of some of these folks doing these role plays, at the end of the role play, they say, by the way, I was the person who 5 years ago was locked in the bathroom attempting to take my life. So there is this real life component to it, which is so important. This grant runs out at the end of September, as Senator Guida said. And so in conversations with Director Skippa from New Hampshire Police Standards and Training, as well as the governor's office, we're looking to expand this to the ability to provide this training beyond just state police to other law enforcement in the state. And the training includes in-depth information about mental illness, de-escalation techniques, and then I mentioned the rehearsals. A significant portion of the CIT training also includes a focus on officer wellness and resilience, and what mental health supports are available to law enforcement in New Hampshire. Sadly, more law enforcement officers die by suicide than are killed in the line of duty, and New Hampshire has experienced its share of these tragedies. There's been an incredible demand for CIT training in the state since we began offering it. And slightly different than what Senator Guida said, this funding would go directly to police standards and training, and police standards and training would be the ones to decide on how the training would be presented. So on behalf of NAMI New Hampshire, I strongly urge you to vote SB 134 as ought to pass, and specifically Section 9. Thank you for your consideration. I'm happy to answer any questions you have.
Thank you very much, Mr. Norton. Are there any questions for the committee? Senator Khan.
Thank you, Madam Chair. Two questions. Thank you, Mr. Norton. Two questions. One, was this recommended by LEAC?
It was not specifically recommended by LEAC, but LEAC took a more general approach to talk about more de-escalation training. It is specifically recommended by the President's 21st Century Task Force on Policing, and their report came out in 2016 recommending that all law enforcement, including all cadets, receive this 40-hour crisis intervention team training.
Yep. Thank you. And second, you're aware of Senate Bill 96, I presume. It carries a lot of the LEAC recommendations that have some funding element to it. Any objection if this was added to that, just so that we'd be able to see in one bill the various police training additions that are on the table, so that when this does go over to the Finance Committee, they see all the parts.
Thank you for your question, Senator. No, I have no objections, and NAMI New Hampshire did testify in support of that bill as well.
Thought so. Thank you.
You're muted, Senator Carson.
The dogs want to eat. Thank you very much. Are there any questions, further questions? Okay, seeing none, we're going to move on to the next speaker, Jane Schurch, I think it's pronounced, and I'm going to have to step away for a few minutes, so Senator Gannon will take over.
Go ahead, Jane. Nice to meet you.
Thank you. Can you hear me? I appreciate your time, and I know that it's late, so I will try to do this as quickly as I can. I'm here to support Section 6 of the bill, which I believe begins on page 20, and this is to establish the New Hampshire Collaborative Law Act. I am a New Hampshire attorney. I've been practicing in the family law area in Nashua for more than 20 years. I'm testifying today as a member of the Legislative Committee of the New Hampshire Collaborative Law Alliance. Collaborative practice is a private, contractually based process of alternative dispute resolution. Collaborative practice in New Hampshire uses a team approach, which uses two attorneys to represent the parties and a neutral coach facilitator, as well as a financial professional. This practice is used primarily in the area of family law at this time. Prior to entering into the collaborative process, parties and professionals sign a participation agreement that sets forth the expectation and parameters of the process. The passage of this legislation will both standardize the contents of the participation agreement in order to ensure that all citizens are using the same process and getting the same process. And also, there is an occasion when the collaborative process is not successful. And in those instances, the parties will resort to litigation. The act will ensure that the confidentiality of the process and that the participants are provided with essentially the preservation of that confidentiality by limiting the ability to enter into evidence information that was gleaned during the process, much like the mediation process that ensuring the confidentiality allows people the opportunity to explore all sorts of options of settlement without being afraid that that might come back to bite them in the litigation process. all practitioners included in the process, including the financial neutrals and the coach facilitators, would be assured of that confidentiality protection. Collaborative practice right now is self-regulated by the New Hampshire Collaborative Law Alliance, which is a nonprofit group of practitioners. Nationally, collaborative practitioners across the country have sought to standardize the collaborative process, and this Collaborative Law Act is based on a Uniform Collaborative Law Act that has been revised to suit New Hampshire. Currently, there are 19 states that have passed similar legislation, and in 5 more states, there is legislation that is pending. This legislation, as indicated by Senator Carson previously, did pass the Senate last session and was included in an omnibus bill that was ultimately vetoed by the governor. So we are hopeful that the passage of this act will be considered by the committee, and doing so will ensure that the alternative dispute resolution process is available to citizens and practitioners alike, and will promote the confidence of this process. So I'm asking for your support in the passage of this bill. Thank you.
Commissioner, does anyone on the panel have any questions? Seeing none, thank you very much for your testimony.
Thank you.
Okay, next we are going to go to Tina Sharby.
Sharby, you have to unmute.
Hi, can you hear me okay now?
Yes, we can.
Sorry about that. Thank you, Madam Chair, members of the committee. I'm testifying with regards to section 11, which could be found at the top of page 47, and also testifying in support of Senate Bill 134. I have already submitted a letter of support, so I'm not going to repeat the contents of that letter in its entirety. It has been a long day. I just want you to know that Easter Seals conducts driver record checks for all our employees who provide transportation services or drive as part of their positions within the organization. And we currently employ over 1,500 staff members and conduct record checks of about 50% or a little bit more than 50% of our staff upon hire and annually. And that results in about 12 staff members being checked with their records on a weekly basis. The record check allows us to be able to make educated hiring decisions and allows us to identify high-risk drivers so that we can keep our staff and the individuals that we serve safe. So this, just a note, is that the current New Hampshire law already allows for the disclosure of the information that we are currently receiving, but the fact that the records have to be requested on an individual basis makes it time-consuming to obtain them. This bill will provide for a more efficient and timely way of obtaining the records while allowing for a quicker process for us to be able to onboard staff, which is very difficult in this current economic environment. I'm going to leave my statements at that. You have the letter that I've already submitted to you, and I'm happy to take any questions, and I thank you for your time.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to go to Rosalind Langiesi. Do we have her?
I do not see Rosalind. Rosalind, if you are here, if you could virtually raise your hand, or if you were calling in by phone by pressing *9. Senator, do I not see her?
Okay, we're going to call Ryan Hale. And I have to step away. I've got to get the charger for my iPad. It's almost dead.
Mr. Hale, if you could virtually raise your hand. Okay.
Okay, there we go.
Can you hear me?
We can, Mr. Hill. Go ahead, sir.
Excellent, excellent. Well, I will keep this extremely short. I know you all are tired and probably very hungry at this point. So thank you for taking, except for Senator French. Let's do look good. Honorable members of the Judiciary Committee, for the record, my name is Ryan Hale. I'm Vice President, Government Relations for New Hampshire Bankers. And just quickly, I come before the committee to rise support of Part 2 of Senate Bill 134, which starts on page 3, line 6. And this is the section of the bill that adds remote online notarization to our notary statute. And that's where I will end my testimony this evening.
Thank you very much. Does anyone have a question? Thank you very much. You have a great evening. Who do we have next?
All right. I do see Joseph Lacaze on our list, so I will allow him in.
All right, thank you. Can everyone hear me?
Joe, we can. Good to hear you again, sir.
Good to hear you too. Thank you. All right. Thank you, Chair and Committee, for hearing my testimony. I know it's been a very long day. I just wanted to speak today on Part 3 of this bill relative to the incarceration under a suspended sentence. My name is, I will be testifying in support of this provision. My name is Joseph Lacaze. I am the Smart Justice Organizer for the American Civil Liberties Union of New Hampshire, and I will be representing them on this testimony. As someone who has actually gone through this process, petitioning a court for a suspended sentence, I could say that this is a very time-consuming and burdensome process. And given the fact that success is the goal of the Department of Corrections, success needs time. People need to be able to prepare for that. And that's what this provision does. What this does is it allows an individual to start preparing for their reentry. And I do want to highlight that this bill does not open the door and make individuals eligible for parole or to go home. It just allows an individual to prepare for that eventuality. And that is key to anyone's success when they're reentering from one world to the next. So I will just keep it short and sweet. And if anyone has any questions, I would definitely like to answer them on the complexities of this.
Thank you, Mr. Lacaze. We have a question. Sorry. Senator Whitley, go ahead.
Oh, thank you, Mr. Chair, and thank you, Joseph, for taking my question. I wonder if you would share with the committee some types of things that, could be done in preparation for release.
Sure, absolutely. So there's numerous factors that a court looks at when they are reviewing a suspended sentence petition, which includes employment, a viable housing plan, as well as letters of recommendation that speak to the character of the person during their incarceration and what their support system is in the community. All of that takes time to gather and to prepare so that a person can look at what the next stage is going to be. And I guess the only way that I could put it into perspective would be if OL, it would be equivalent to OLS, the way things currently are, it would be equivalent to OLS saying that an LSR was not allowed to be introduced until exactly a week before its hearing. And then, no one would be able to review the bill, look at language and do all that. So that's all that this is doing, is giving them that chance.
Hey, thank you very much for, are there any further questions? Okay, seeing none, thank you very much for your testimony, and thank you for hanging in there with us this afternoon.
No problems. Thank you very much. Everyone have a great afternoon. Well, great evening, I should say now.
Thank you. Next, we're going to call David Goldstein. Good evening, Chief.
Good evening. Thank you very much. Madam Chair, members of the committee, for the record, my name is David Goldstein. I'm presently the Chief of Police in the city of Franklin. Been a police officer for 41 years, and during that time, I've been involved as a subject matter expert in the CIT training for not only NAMI, but various police departments that have implemented the initiatives as well. I've worked in the area of law enforcement mental health since the mid-1970s. And I merely want to mirror what Mr. Norton had to say from NAMI, and certainly we would appreciate the extension of the funding. And I want to support this for both NAMI and for the New Hampshire Police Academy. And I'm happy to answer any questions that the committee might have.
Okay, thank you very much. Are there any questions from the committee? Okay, seeing none, thank you very much, Chief. Margaret, that was the last person I had that was signed up. Do we have folks in the waiting room?
We do have one hand raised, Diana Fenton.
Okay, why don't we go ahead and call Ms. Fenton?
Good evening.
Good evening, Ms. Fenton.
The only thing worse than being the first speaker is the last speaker, especially at the end of the very last night. So I think I win the prize. My name is Diana Fenton, attorney with the Department of Education. It is a pleasure to be here before you tonight. The Judiciary Committee, as a former prosecutor, I feel right at home here. So I'm speaking at the behest of Senator Khan, who was kind enough to sponsor the bill for the Department of Education. It's Part 8. And I'm going to minimize my screen so I can go through this with you. This bill ensures that children are safe in the classroom, and it is really a partnership between the school districts and the Department of Education. It recognizes the difference between employment and credentialing. Last session, the legislature passed a bill, House Bill 1520, which gave the Department of Education authority to run a criminal background check on first-time applicants for a New Hampshire teaching credential. However, that bill was lacking the necessary language from the Department of Safety, which would allow the release of the FBI record to the department. So there's a real critical piece, language-wise, that was just lacking. By way of relevant background, and I will be brief on this, prior to that bill, House Bill 1520 being passed, it's important to understand that the criminal background check for education was a matter of employment only. Department was licensing people without doing a criminal history records check, and the department feels that as a matter of child safety, that's inappropriate. There are a list of offenses in RSA 189.13a, which would prohibit individuals from working as educators in public schools within the state. That list of offenses is narrowly tailored to address child protection offenses, prostitution, child pornography, sexual assault, murder, endangering the welfare of a child, but there are a lot of offenses that are not on that list. Without the Department of Ed having the ability to run a criminal history check prior to issuing a credential to teach, this means the department might be issuing a credential to an individual who is unemployable. That doesn't support the field, that doesn't support New Hampshire children, and it doesn't support New Hampshire families. This bill does not take away from the district's ability to run a criminal history record check. That is part of that partnership piece. They still have the obligation to run the background check as part of employment. Again, this is just a real partnership. So what I'm going to do quickly is on Part 8, on the first page, lines 13 through 16, that's really just an editorial change to clean up the language, nothing of substance. However, I'm happy to take any questions as we go through. So on the same page, lines 24 through 27, this makes it clear that if an applicant for employment has a Section 5 violation, which would prohibit employment, the superintendent has to notify the Department of Education. That language mirrors the Code of Conduct for educators, which was passed in late 2018. Lines 28 through 31 say that the criminal record check, the history has to be destroyed within 60 days. Prior to this amendment, there was some provision that required it to be done immediately, others 60 days. This way, we're just making it streamlined and equal across the board. Going to page 2 of the amendment, line 5, this is cleanup language that the Department of Safety requested to make it clear that the previous paragraphs were still applicable to this section. Lines 18 through 26 struck this because some of this language is simply no longer applicable. And some of this language violated the regs from the FBI. This bill really is a partnership between the Department of Education and the Department of Safety. We want to thank our partners at the Department of Safety for their time. A lot of this language change is because the FBI has very strict regulations about what they expect and what they look for. And the phrase on line 18 that's been struck, other educational staff, was a flag and a problem. It's problematic language for the FBI to continue to release these records. So we've gotten rid of that. And we've moved substitute teachers up above into line 6. So we have not inadvertently excluded them. One of the big pieces of this bill is DOE is now going to partner with higher educations, so all the colleges that do teacher prep programs. One of the issues we have encountered is teacher prep programs in higher eds. They cannot receive the FBI criminal history check. They can get the state check, but they can't get the FBI check. That's because they are not a governmental entity. But the Department of Education is. So this is a unique opportunity for the department to partner with our teacher prep programs that we obviously have a vested interest in, to say we will run the criminal background check for all these people who want to be part of the teacher prep program. In lines 35 through 37, we still defer to the school districts to say you may still do an additional check. You don't have to. You can rely on the department's check, but you may, because it is the school districts that maintain the liability. Once that student is placed as a student teacher, you'll see this in lines 27. Once they're placed as a student teacher, the school district has the obligation to then take that person on and do the background check. Moving to page 3, and I apologize, I'm going quickly, but we're past 6 o'clock. So for everyone's sake, and Senator Carson has hungry dogs. So
no, they've already been fed.
Oh, okay. Well, then I'll slow down. Moving on to page 3, we have a new section, and that's 189.13C. And this is really the language that supports the Department of Education running a criminal background check for first-time applicants for a New Hampshire teaching credential, as we've talked about. This is, again, this was passed in House Bill 1520 last session, and this is going to flush this out. And candidates as defined, which is, as I mentioned previously, people in educator prep programs in New Hampshire higher eds. Talks about that the department shall complete a confidential criminal history record check on all first-time applicants. This is, again, language from the Department of Safety, just as SAUs would do for purposes of employment. In section B, there is some rulemaking authority which will allow the department to adopt rules to really flush out how we will coordinate and work with the higher eds to do this process. We will not be issuing credentials to teacher prep candidates. We will be clearing them of the section 5 violations. I want to be clear about that. We issue credentials to teachers who have passed all the other requirements. This would be a clearance. So that's what section B speaks of how the mechanics of that will work. Section C in line 17 says the criminal history records check on a candidate will be valid for a period of 3 years, which generally speaking is the length of a teacher prep program, so they will not be subject to multiple criminal background checks. Section 3A in lines 18 through 23. This is very template language provided by the Department of Safety. This is required by the FBI in order to release this record to the Department of Education. Again, the Department of Education, because it is a governmental entity, is allowed to have these records, but this is not something that the department has done historically. So we have to have this enabling language, if you will. Similarly, section B on lines 24 through 30 is language that is in the employment statute. It just talks about if the fingerprints are invalid, they can have 2 attempts. And if after 2 attempts, it is still invalid, what the department may do. Same language that's in the employment statute. Section 4A, lines 31 through 33, talks about the department shall maintain the confidentiality of these records and then destroy the information within 60 days, similar to what you saw above, keeping all that time frame the same. Department may require the applicant to pay the actual cost of the criminal history records check. I believe it's about $42, but please don't quote me. That's a number that comes from the Department of Safety. Section 5 is similar to employment. It's verbatim to employment. And this is the list of offenses which would prohibit an individual from being employed as a teacher in New Hampshire classrooms. These offenses, I actually have a cheat sheet of these offenses. I shared this cheat sheet with Senator Khan, but I will just reiterate that it is narrowly tailored to protect children. So it's child pornography, it's prostitution, it's endangerment. There are murder is prohibited and sexual assault. But there are a lot of offenses that are not: DWI, theft, first degree assault, second degree assault, arson. There's a plethora of them. And those are the offenses that a district would be allowed to look at to say, maybe this person's not the right fit for being a teacher in our district. If you will allow me, the system that we're designing here is that the Department of Education would be similar to the federal Constitution, where we are the floor of protection. We're just checking for those Section 5 violations. And the districts are the state constitution. They can be more protective, but not less protective. In Section 6, lines 6 through 9 on page 4 of the amendment, the department again has rulemaking authority talking about the appellate rights of an individual who's been denied a teaching credential or a clearance if they are a teacher prep program. Then in lines 12 and beyond, this is something I'll defer more to Senator Khan on this, but this is a committee that he would like to establish to explore the role the Department of Education can play with private schools in background checks, keeping in mind that similar to higher eds, private schools are not allowed to receive the FBI background check. And that is problematic, perhaps. And it could be a role that the Department of Education could assist them with, similar to what we are doing with teacher prep programs. And we would like the opportunity to more fully vet that with our partners in private schools and non-publics. So I'm going to wrap up at 6:11 at night and say that I'm available to take any questions, and I appreciate your patience.
Thank you very much for your testimony. Are there any questions from the committee? Senator Khan.
Thank you, Madam Chair. Thank you, Diana, for hanging in with the committee and your excellent review. There is an amendment that we're preparing and actually is prepared, but to share with the committee. I just wanted you to confirm that and for us to alert the committee that that'll be forthcoming.
Yeah, so that amendment's been drafted, and those are the provisions that I went over. What you have before you is in large part very similar, but there were some tweaks. So yeah, that amendment's been drafted and it will be available for your review.
Thank you.
Thank you very much. Do you have an additional question, Senator Khan?
No, thank you, ma'am.
Okay. Senator French, do you have a question?
No, just scratching my head, Madam Chair.
Okay, just want to make sure.
Thank you. It was
Okay.
just a little itchy.
Okay. All right. It seems we don't have any more questions for you, Ms. Fenton. Thank you very much for hanging in there with us this evening. And
My
we'll
pleasure.
look forward to getting your suggestions.
Thank
Margaret,
you so much.
is there anybody else?
Yes, we have two hands raised, Brian Blackton and Brian Deere, and that is it.
Okay, Brian Blackburn?
Blackton.
Okay, why don't we call him first?
Hi, can you hear me?
Yes, we can.
Thank you. As I stated earlier, as an FFL, I do not have the bill in front of me. It was given to me at the last minute here, so I am at a disadvantage. But according to Section 1 regarding laser pointers, doctors law enforcement contractors are exempt from using and pointing lasers. In these times, many firearms have lasers attached to them, and in a self-defense situation, sometimes there is an instance where a person might need an exemption to point a laser at a vehicle to protect themselves or another party. That may want to be looked at to do with this part of the bill. As far as section 3, third, as a former counselor at the state prison, I would definitely ask for changing timeline for prisoners to petition for suspended sentences, as most units at the New Hampshire State Prison have 2 counselors for approximately 300 inmates. And there's a lot of programming that has to go on for that to occur. So that, I believe, is a necessary item to help them out. In section 9, I have been personally to 6 friends, police officers' funerals, and know of 3 others. And I would definitely support section 9. In 10, I am a little confused because I don't have the whole verbiage, but any person who knowingly uses any device, including a mechanical or electronic device, I heard the word drone, and there is law out there on drones at this point. But I have a problem with the word shall be guilty of a misdemeanor. I don't like the word shall as a former police officer. I like it to be may, because there are instances where people do things for the police, like say there's a meth lab in my neighbor's house and the police can't do anything without someone stepping in. But if the police ask them to do it, they become an agent of the police, and it's no good as fruit of the poisonous tree. But yet on the other hand, like the woman who spoke, the invasion of privacy is clearly wrong. So that's why it should be may, because instances differ and every case is different. And that's why the shall might be a poor word choice and should be may. And that's all I have. And I thank you for your time.
Thank you very much for your testimony. Are there any questions from the committee? Okay. Senator Gannon?
Yeah, I think the bill was clear on with the use of laser pointers, that law enforcement uses are exempt and other lawful uses are also exempt. Specifically, it says rangefinders exempt too. But you said you didn't have the bill in front of you, I believe.
Yeah, in under RC, I believe it's 631.3. I didn't see any other lawful use. I may have missed it, but I believe that's the RSA.
In the bill, I think it's there, given the
Okay.
exemptions.
And like I said, I unfortunately don't have the bill in front of me. It was given to me last minute.
Okay.
Okay, are there any further questions? Senator Gannon again.
Last one. Just where was that will and shall? I wanted to look at that.
Section 10.
Okay.
On about the drone.
I will look at that.
Looking in someone's window.
I'm good.
Depending on the instance, it could be helpful to law enforcement, and then it could be an invasion of privacy. And to put a shall on something that helps the police is not good. But an invasion of privacy is good. So there just needs a possibility of some rethought on that word.
I'll read it over. Thank you.
Okay, any more questions for Mr. Blackton? Okay, seeing none, thank you very much. Let's go to the last person, Margaret. Good evening, Mr. Deere.
Good evening, Madam Chair and members of the committee. Thank you for allowing me to speak. As Mr. Kelly mentioned, I am Brian Deere. I'm the Executive Director of the National Association of Settlement Purchasers, here to speak on support of Senate Bill 134, Part 5, and also in support of the proponent's amendment. As Mr. Kelly and Mr. Ullman did a pretty good job of covering everything for the most part, but I wanted to not belabor any of those points, but In addition to being the executive director of the trade association, I'm also a practicing attorney in a different state that has a similar act such as the one that's being proposed in New Hampshire. So I wanted to make sure if the committee had any questions about the mechanics of the bill, that I make myself available for that. And then also finally, just kind of to follow up very briefly on some of the comments earlier regarding the request for the 3 bids, as well as the suggested amendment to address those. I think it's very important for structured settlement recipients in these cases, one, to have the opportunity to receive that information, to be advised that they have the opportunity to seek out other offers. It's been my experience, most people involved in these transactions actually do that in advance. But I do want to make sure, as Mr. Ullman and Mr. Kelly spoke of previously, that we keep in mind the very important privacy provisions regarding these transactions, and also just considering the speed and sometimes the necessity of these transactions have for people involved in these transactions. Unfortunately, especially during this year, during the COVID pandemic, many of the transactions that I have seen have been directly related to those, and sometimes and oftentimes speed is of the absolute essence for some of these transactions to get done. And some of the suggestions of the judiciary, I think, would be more damaging to New Hampshire residents than beneficial for them. But I'm not going to belabor too much of the point. I think Mr. Kelly and Mr. Ullman did a very good job of covering most of our points, but I do want to make myself available in case there's any questions about the mechanics, about the process in court, how that operates, if there are any. With that, I'll let you get back to your evening.
Thank you very much for your testimony, Mr. Deere. Are there any questions from the committee? Okay, seeing none, thank you very much. Margaret, no one else?
Nobody else.
All right. Okay, we're going to go ahead and close the public hearing on Senate Bill 134. I will thank all of you for hanging in on what was a very long and involved testimony this afternoon on both of these bills. So that's it for tonight. So I will entertain a motion to adjourn.
So moved.
Motion.
Okay, who was first? I saw Senator Khan had his hand up and Senator French.
Motion to adjourn, man.
Okay, seconded by Senator French.
Twice.
Okay, I'm going to go ahead and call the roll. Senator Khan,
Yes.
Senator Whitley,
Yes.
Senator French,
No.
Senator Gammon,
Yes.
and Senator Carson, yes. I'd also like to
4-1.
thank, I know. I'd also like to thank Ms. Waterhouse and Jenny, our secretary, and our attorney, Mr. Lehman, for hanging in there with us this afternoon. And thank you for all your work today. And
Great
we
job,
will see
Sharon.
you soon. Okay?
Thank you.
Take
Bye.
care, everybody.
Night.